recess of the committee at any time. As a reminder, I ask all members to keep themselves muted when they are not being recognized. The staff have been instructed not to mute members except where a member is not being recognized and there is inadvertent background noise. Members are also reminded that they may only participate in one remote proceeding at a time. If you're participating today, please keep your camera on, and if you choose to attend a different remote proceeding, please turn your camera off. This hearing is entitled Protecting Renters During the Pandemic, Reviewing Reforms to Expedite Emergency Rental Assistance. I now recognize myself for 4 minutes to give an opening statement. From the very beginning of this pandemic, I have sounded the alarm about the urgent need for congressional action to avert a massive spike in our national eviction crisis. As chairwoman of this committee, I understand the devastating impacts evictions have on families, and I also understand how much landlords, particularly small mom and pop landlords, are struggling because of unpaid rent. I also recognize that evictions increase the spread of COVID and have the potential to seriously set back our national economic recovery. That is why I've worked around the clock on this issue. I'm reminded as I've worked on this issue that we have extended the moratorium between the Congress of the United States and CDC 6 times. Thankfully, due to the hard work of this committee, in 2020, Congress passed $25 billion in emergency rental assistance and provided an extension of the federal eviction moratorium. Several months later, under the leadership of President Biden, Democrats passed an additional $21.6 billion in emergency rental assistance as part of the American Rescue Plan Act. But our work is not done. I'm very concerned about data showing that state and local governments have only used 11% of the $46.6 billion in emergency rental assistance funds that are available. There's no question that the funds are not reaching landlords and renters quickly or widely enough. In addition, the Supreme Court's action along partisan lines to lift the CDC's eviction moratorium puts millions at risk of eviction, even as the Delta variant causes a deadly resurgence of the virus. That is why I have introduced new legislation, the Expediting Assistance to Renters and Landlords Act of 2021, which is designed to make sure that individuals and families are not put out of their homes while this virus continues to harm communities across the country. This bill would allow landlords to apply directly for back rent they are owed, even if a renter is unresponsive, as long as the landlord provides notice and meets other conditions, including a requirement that tenants may not be evicted for at least 120 days, and that the landlords would be paid for those 120 days following the first request for assistance. The legislation would also require grantees receiving emergency rental assistance funds to accept self-attestations from tenants and to provide funds directly to tenants when the landlord is unresponsive or refuses to participate. The legislation also gears up outreach, working very closely with the Treasury. We've come up with many ways by which to modify these applications. So the legislation, again, also gears up outreach to increase public awareness of the availability of emergency rental assistance funds, providing funding for mailings, radio, TV, and internet ads, and ensures grantees have the resources and help to get the funds out the door. These steps and others in the bill will cut down barriers preventing the robust rental assistance funding that Congress has provided from reaching renters. Today, we will also discuss legislation Ranking Member McHenry has introduced regarding rental assistance. While I have some serious concerns with the Ranking Member's bill, I believe that we are aligned on our goal to expedite assistance to those in need. So I want to work with him, and I'm hopeful that we can work together, and this could be a bipartisan bill. I look forward to discussing both bills with our panel of experts today. I now recognize the ranking member of the committee, the gentleman from North Carolina, Mr. McHenry, for 5 minutes.
Thank you, Madam Chair, for holding today's hearing. Thank you for those encouraging words of outreach. Now that we are 5 months past when committee Republicans filed our bill, the Renter Protection Act. And I want to thank you for attaching that bill to this hearing, which is supported by every Republican on the committee. The bill makes common sense reforms to Treasury's rental assistance programs to get help to renters and landlords now. It is a bill we should have considered months ago, before the eviction moratorium expired and before renters and landlords had the rug pulled out from underneath them. Committee Republicans have been raising the alarm since it became clear the Treasury Department was failing to get renter relief out the door. To state the obvious, the Emergency Rental Assistance Program isn't working. Congress gave the Treasury Department more than $46 billion to help renters and property owners survive the pandemic. Back in May, I asked Treasury to provide basic data that would help us understand where all that money is and why it hasn't reached renters. They couldn't answer those questions, and they still can't. We had a hearing late in July with a HUD secretary who was profoundly unprepared to answer basic questions about this important program. We ask, is rental assistance money being used to help COVID impacted families? And she told us, quote, I have no idea. Let me repeat. The HUD secretary said, I have no idea. That is unacceptable. The whole process has been unacceptable. It has been 2 months since the federal eviction moratorium expired and several weeks since the Supreme Court struck down President Biden's last-minute extension. And here we are again, asking why isn't the program working and how can we fix it? Is Secretary Yellen here? No. Did the majority invite her? No. And she is in charge of deploying these monies. Committee Republicans did, and to no one's surprise, she didn't agree to come. And again, she didn't come to answer these basic questions that we all have both on both sides of the aisle. 3 days ago, Democrats finally put forward their alternative. You may have not heard or read about it, so I'll summarize it for you. More red tape, more bureaucracy, more delays. Simply put, Democrats' bill will not fix the Biden administration's abject failure. So here's what we should be doing. Number one, we should consolidate all the rental assistance programs into one easy to manage program for localities to administer. 2, reform the program so money goes to property owners to settle back debts so families can stay in their homes. And 3, we need to make it easier for property owners to participate on behalf of residents. Finally, we have to require grantees to move faster, for example, by accepting bulk applications. It seems like Democrats in Washington forgot that the purpose of the program is to pay back rent. This isn't difficult. To get the program back on track, it simply requires that our solutions be targeted, timely, and tied to COVID. But the bill put forward by Democrats would only make things worse, not better. So instead of actually solving problems today, there will be more finger pointing at the previous administration by my Democrat friends, and more proposals to empower liberal activists by my Democrat friends, and zero plans to hold the Biden administration accountable for their failures. Very typical of my Democrat friends right now. This is a shame. Since it appears our bill won't get a fair shake in this committee, this morning I filed a discharge petition for the Renter Protection Act. I would encourage every member to sign on to it. And with that, I look forward to the panel, and I yield back.
Thank you very much. Much of what the ranking member is talking about needs to be done. It's in this bill. Mr. Cleaver, you are now recognized for 1 minute. I can't hear you, Mr. Cleaver. Please unmute.
I apologize, Madam Chair. The legislation being discussed at this hearing, the Expediting Assistance to Renters and Landlord Act of 2021, proposes several changes to ERA1 and ERA2 that will ensure that the federal emergency rental assistance funding that we fought so hard for in this committee is continuing to reach those who are in need. As the COVID-19 pandemic continues to surge, far too many American families have been and will be subject to the horrors of an eviction. Many small landlords who have invested their retirement incomes have now to worry about whether or not their property will go into foreclosure. Like many of you, I have been frustrated at the slow pace at which state and local governments have been implementing the Emergency Rental Assistance Program, and there is no time to waste in making the reforms necessary to get funds out the door as quickly and efficiently as possible. I look forward to this hearing from today's witnesses. I want to thank you, Madam Chair, for your leadership and for convening this hearing. Thank you very much. I yield back.
You're so welcome. I now recognize the gentleman from Arkansas, Mr. Hill, for 1 minute.
Thank you, Madam Chair. Where is Secretary Yellen? It's been 5 months since the Treasury Secretary testified before our committee. Yet the Biden administration seems to feel no sense of urgency to help renters and mom and pop landlords who need it most. No sense of responsibility to answer to Congress, and no sense of shame over complete mishandling of the Emergency Rental Assistance Program. Instead, we have the distinguished chairman from South Carolina, Mr. Clyburn, browbeating governors and trying to shift blame to them from the Treasury Secretary. But it's a mistake, and we're hurting over 1 million families estimated to be evicted in the next couple of months. Republicans have a better solution. The Renter Protection Act, which would simplify needlessly complicated rental assistance programs, get the money out faster, and actually help the people that Congress intended, those who lost a job and got behind on their rent due to COVID-19. If my friends across the aisle are serious about a solution, I urge my friends to include the Renter Protection Act in Monday's committee action. Thank you, Madam Chair, and I yield back.
Thank you very much. I want to welcome today's distinguished witnesses to the committee. First, we have Mr. Kadeem Morris, a supervising attorney with Community Legal Services. Next, we have Ms. Margaret Salazar, the Executive Director of the Oregon Housing and Community Services Department. Next, we have Mr. David Schwartz, the CEO, Chairman, and co-founder of Waterton and Chair of National Multifamily Housing Council. Next, we have Ms. Diane Yentel, the President and CEO of the National Low Income Housing Coalition. Now I recognize the gentleman from Massachusetts, Mr. Lynch, to introduce our last witness. Mr. Lynch? Is Mr. Lynch on the platform?
Yes.
Well, oh, okay, while we were waiting for Mr. Lynch, who wanted very much to introduce our witness, I'll move on and I'll introduce Mr. Gilbert Winn, the CEO of Winn Company. Without objection, your written statements will be made part of the record. Each of you will have 5 minutes to summarize your testimony. You should be able to see a timer on your screen that will indicate how much time you have left, and a chime will go off at the end of your time. I would ask you to be mindful of the timer and quickly wrap up your testimony if you hear the chime. Mr. Morris, you are now recognized for 5 minutes to present your oral testimony.
Good afternoon. My name is Kitty Morris, and I am a supervising attorney in the Housing Unit of Community Legal Services of Philadelphia. Community Legal Services helps more than 10,000 people per year with legal problems that threaten their home, health, income, and more than 2,300 households per year who are facing evictions due to the COVID-19 pandemic. I'd like to thank Chairwoman Maxine Walters and members of the House Committee on Financial Services for inviting me to speak today. The COVID-19 pandemic has exacerbated the pre-existing housing crisis in the United States, causing more people to join the ranks of the housing insecure. The ability to access safe and affordable housing is not guaranteed in the United States. However, the collateral consequences when a family is evicted are clear and immediate. The faces of the evicted are the faces of the vulnerable members of society. Studies have found that single mothers, most commonly Black and Brown, make up the majority of those affected by evictions and forced move. The grim reality in Philadelphia, where 71% of the annual eviction cases are filed against communities of color. The pandemic has exacerbated difficulties for these communities, mainly Black, Brown, seniors, and people living with disabilities. These communities are most likely to have lost income during the pandemic, putting them at greater risk of an eviction filing and subsequent homelessness and housing instability beyond the pandemic. The health consequences, combined with the financial hardship of having your job disappear, has shattered the already shaky foundation upon which vulnerable families stood. People who were struggling to make ends meet before the pandemic were forced to make the bitter choice of risking their health of the families that they live with, or working during the pandemic and potentially contracting the virus, or facing the long-term consequences of unemployment and increased household expenses. In Philadelphia, the effective delivery of rental assistance to vulnerable households has prevented displacement and, as a result, prevented the community spread of COVID-19. The Philadelphia Eviction Diversion Program partners with the city's Emergency Rental Assistance Program to ensure that people are able to access assistance to the benefit of both landlords and tenants. Through targeted outreach and supportive services, Philadelphia was able to build a rental assistance program that could preserve the landlord-tenant ecosystem. The demographic data provided by the City of Philadelphia demonstrates that rental assistance dollars are reaching vulnerable communities. 65% of the families assisted were Black or African American, 60% of the applicants were female, and over 70% of the households served had a household income below 30% of the area median income. Landlords who were struggling with their mortgages were paid, and tenants who were behind on their rent were not displaced. The Eviction Diversion Program provides a forum by which landlords and tenants can meet and discuss issues without the pressure of a court filing. The program also uses highly skilled impartial mediators to create a forum where landlords and tenants can resolve issues, and tenants are automatically assigned a housing counselor who work with them throughout the process, assisting them with the rental assistance application and also coordinating any other supportive services. For rental assistance programs to operate effectively, administrators cannot create additional barriers for tenants and landlords to jump through. If the stated goal of the program is to prevent evictions for vulnerable households, then municipalities and other administrators should limit the amount of paperwork and forms of verification that tenants and landlords need to submit. Under the American Rescue Plan, households who have not experienced a change in income but have experienced an increase of expenses are eligible to apply. This opens the door for a significant portion of the population, including the elderly and disabled, to participate in the program. Increased expenses during the pandemic are reflected in the cost of food, cost of transportation, and often the cost of burying family members who have suffered from COVID. These vulnerable households shelter the increased costs without an increase in income, and most are unable to afford market rate rent based on their income. Sadly, the proposal H. Bill 3913 proposes to limit the usage of the unspent funds under the American Rescue Plan. If getting the money out to landlords and tenants is a top priority, the federal government should not take any steps to limit the flexibility that is currently given to program administrators to set up both programs and supportive services that gets the money paid out. The proposed changes outlined in the Emergency Rental Assistance Program in HB 5196 are vital to the survival of the landlord-tenant ecosystem. provided flexibility for landlords to apply without tenants who are unresponsive, requiring grantees to inform those tenants that their arrearage has been paid and that they're covered by the 120-day eviction prohibition, places landlords and tenants on even footing by allowing tenants to self-advocate with the information. The satisfaction of outstanding money judgments and the sealing of cases are vital, as evictions have a long-term consequence. In closing, I would like to encourage the federal government to take steps to adopt the proposed changes outlined in HB 5196 and make it easier and create additional flexibility for agencies to administer their rental assistance programs. Thank you for your time.
Next, we will go to Ms. Salazar. You are now recognized for 5 minutes to present your oral testimony.
Thank you, Chairwoman Waters, Ranking Member McHenry, and members of the committee. Thank you for the opportunity to testify today. For the record, my name is Margaret Salazar, and I'm Executive Director of the Oregon Housing and Community Services Department, and I also serve as the Vice Chair of the National Council of State Housing Agencies. My agency, like 27 other state HFAs, serves as a statewide administrator of the Emergency Rental Assistance Program. Every month, state ERA administrators have increased the rate at which they have distributed assistance. States delivered more than $1.6 billion in the month of August, the highest level of any month to date. State programs on average have funded more than 1/3 of the applications that they have received, with many funding 50% or more. The ERA program has provided a lifeline to more than 1 million vulnerable renters and made thousands of landlords whole. Since the beginning of this calendar year, my agency, OHCS, has obligated more than $204 million in rental assistance. This is the equivalent of our entire ERA-1 allocation, but it represents a combination of both state and federal funds. Of this total, nearly $35 million is federal ERA assistance. In the last month, our agency has taken bold action to speed application processing. We have hired more than 60 temporary staff and brought on an outside vendor to boost capacity for our local partners on the ground. We have created self-attestation forms, disseminated informational videos, and translated materials into multiple languages. We have partnered with community-based organizations to increase outreach and support, particularly in communities of color. But there are limits to what ERA can achieve as currently authorized. We agree with Chairwoman Waters that legislation is needed to further reform this program to greatly strengthen its effectiveness. NCSHA supports Chairwoman Waters' Expediting Assistance to Renters and Landlords Act. We also encourage you to make several additional statutory improvements to further strengthen the program, which are in my written statement. Any ERA program reforms must reflect the fundamental balances that agencies at all levels of government must strike. The first is balancing renter protection with landlord participation. NCSHA has repeatedly acknowledged the extraordinary efforts of landlords to keep people safely housed during this pandemic. While some landlords have declined to participate in rental assistance programs, others have been unable to do so because a tenant is not responsive or has vacated the unit, leaving the landlord with unpaid arrears. We support the provisions in Chairwoman Waters' proposal to allow landlords to apply for ERA on behalf of tenants, even if the landlord is unable to gain the renter's consent or because the tenant is not responsive or has vacated the property. The second important balance is between equity, efficiency, and accountability. ERA administrators have been accused of unnecessarily prioritizing documentation requirements to prevent fraud over the urgent need to make rental assistance available. But even with the new flexibilities in U.S. Treasury rules as of 2 weeks ago, the ERA statute and Treasury requirements still impose significant accountability on ERA administrators. Our experience in the field tells us that verbal assurances from U.S. Treasury will not guide federal agency oversight, either through federal or state or local audits. State and local officials are on the line for meeting this unprecedented emergency, and we are acting in good faith when we work to balance urgency and accountability. We support the provisions in Chairwoman Waters' proposal that would provide a safe harbor to grantees so that they would not be subject to liability to repay assistance provided in good faith, relying on the attestation of the tenant. The third balance is between current and coming demand. My team in Oregon and my colleagues around the country are committed to helping as many eligible renters as quickly as possible. We understand the urgency. The unevenness of the economic recovery and the clear demand for the program suggests that ERA will become even more needed in the months ahead. In addition, there are indications that utility arrearages remain substantial. Estimates of unpaid utilities range from $10 billion to $30 billion. We support the provision in Chairwoman Waters' proposal that would extend the time period during which an individual household may receive ERA assistance to up to 24 months. The administration has accurately said that the launch of ERA required building a new national infrastructure for rental assistance and eviction prevention that did not previously exist. Additional improvements to the ERA statute can help build out that infrastructure for even greater impact. Thank you, and I will be glad to answer any questions.
Thank you very much, Ms. Salazar. Next, we will go to Mr. Schwartz. You are now recognized for 5 minutes to present your oral testimony.
Chairwoman Waters, Ranking Member McHenry, and members of the committee, it's my privilege to appear before you today to speak on behalf of the multifamily rental housing industry, the National Multi-Housing Council, the National Apartment Association, and our nation's 40 million apartment households on the urgent reforms needed to the Emergency Rental Assistance Program, or ERAP. My name is David Schwartz, and I'm CEO and Chairman of Waterton, headquartered in Chicago, Illinois, with regional offices throughout the United States. Waterton is a real estate investment and property management company with a focus on U.S. multifamily properties. I'm also the current chair of the National Multi-Housing Council, or NMHC. Our country has faced unprecedented challenges for the past 18 months, creating significant hardships for America's renters and jeopardizing the stability of the housing sector. We commend the work in this committee in creating the Emergency Rental Assistance Program and appreciate your continued work to ensure the ability of ERAP to serve those in need. Throughout this crisis, rental housing owners and operators have continuously worked to address the needs of our residents, employees, and communities, deploying various means to accommodate the housing challenges presented by COVID-19, despite their own financial uncertainty and economic losses. The apartment industry knows better than anyone the importance of providing a safe, secure place we call home, and it's a responsibility we do not take lightly. But the housing industry cannot shoulder COVID relief efforts alone. Moreover, housing providers were severely impacted by eviction moratoriums, which just merely shifted the economic hardships of the pandemic to housing providers. One-size-fits-all federal moratoriums were and are unsustainable and failed to address the underlying financial distress of residents. Instead, ERAP is a critical stabilizer for residents and housing providers alike and the most effective eviction mitigation tool at our disposal. This is why it's urgent to focus on implementing workable solutions for renters and housing providers facing barriers and delays in the distribution of vital rental assistance funds. The apartment industry is playing a key role in helping execute the rental assistance program and to secure benefits for their residents. Given the widely varying nature of rental assistance programs and the multi-jurisdictional footprint of many apartment firms, this necessitates significant commitment of resources and staff to vet dozens or even hundreds of programs with differing eligibility, application, and distribution policies. We applaud this committee's focus on reforming the program and appreciate that H.R. 5196, the Expediting Assistance to Renters and Landlords Act of 2021, and H.R. 3913, the Renter Protection Act of 2021, address many of our concerns. Our written testimony provides detailed recommendations for unlocking the flow of ERAP funds and addressing barriers to the delivery of relief to those in need. In particular, we support efforts to help jurisdictions ramp up delivery of rental assistance benefits, including streamlining onerous application and documentation requirements, ensuring eligibility aligns with those residents in need of support, leveraging housing provider capabilities to assist with application processes, and embracing practices and technologies with proven operational success. Importantly, we caution against the imposition of new program requirements unrelated to the accelerated distribution of funds that further or create new barriers to participation in ERAP programs. Instead, we urge a singular focus on those efforts that can lessen the burden of program administrators and applicants while improving the outflow of benefits. There is also a pressing need to address the ability to secure ERAP funds when residents are unwilling or unable to cooperate with the application process. Congress must enable housing providers to apply for rental assistance on behalf of residents who are unresponsive, have vacated units, or otherwise unavailable. Without action to address ERAP's current limitations and increase participation in the program, renters are faced with further uncertainty and a mounting debt cliff, while housing providers are forced to address rental losses through foreclosure, bankruptcy, removal of the property from the rental stock, and other measures with long-term market impacts. We are dedicated to working in partnership with policymakers at all levels on addressing the challenges of COVID-19 while advancing proven solutions for long-term housing affordability. This committee's attention to addressing the root causes of housing instability is vital, and we're committed to efforts that would bolster housing assistance to renters, increase housing provider participation in federal housing programs, break down barriers to the provision of rental housing, and increase housing choice for renters.
Thank you, Mr. Schwartz. Next, we will go to Ms. Yentel. You are now recognized for 5 minutes to present your oral testimony.
Thank you. Chairwoman Waters, Ranking Member McHenry, and members of the committee, thank you for the opportunity to testify today. When the Supreme Court lifted the federal eviction moratorium, it eliminated the last federal protection, keeping 6.5 million families behind on their rent, stably housed. The unprecedented resources that Congress provided for emergency rental assistance has yet to reach many of them. Now they are at risk of losing their homes as the Delta variant surges. The urgency of getting assistance to tenants and landlords cannot be overstated, but many communities are spending their ERA allocations much too slowly. Just $7.5 billion of the first $25 billion of ERA has been spent or obligated. While ERA helped nearly 1 million households through July, at least another 1.2 million submitted applications but have yet to receive aid. Many others struggle to complete applications due to complexity, inaccessibility, or documentation requirements. Some programs are successfully scaling up. New Jersey, Virginia, Texas, Massachusetts, and DC have all spent over half of their ERA1. 6 states have spent more than 30%, and several states have made major recent improvements. Dozens of cities have spent over 70% of their ERA1. These programs make clear that success is possible, but they are outliers. 17 states and many localities have spent less than 10% of their first ERA allocation. Some were slowed down by state legislatures or city councils. A few received more ERA than needed due to Congress's faulty formula allocation. Many struggled with landlords' refusal to participate in programs. But the primary issue with slow ERA spending is that many programs are not following clear Treasury and White House guidance and are not adopting evidence-based best practices. Slow spending ERA programs tend to do little outreach. They don't hire enough staff to process applications. They have long and complicated applications with overly burdensome documentation requirements. For example, fewer than 17% of programs explicitly allow renters to use self-attestation to document income or housing instability. This, despite Treasury guidance that has, since March, allowed self-attestation for all eligibility criteria. Only 28% of programs explicitly allow direct-to-tenant assistance, despite it being permissible and critical to keeping renters housed when landlords refuse to participate. It's unfortunately clear that by now, if flexibilities and best practices remain optional, many programs will not adopt them. So the Biden administration should continue to use all available tools, including their ability to recapture and reallocate ERA funds, to require best practices in all programs. And Congress should consider statutory changes to turn flexibilities and best practices into requirements. Legislation introduced by Chairwoman Waters builds off existing Treasury guidance and addresses the root causes of slow ERA spending. NLIHC has deep reservations about allowing landlords to receive ERA without tenant involvement. The legislation provides important protections in such cases to lessen fraud or tenant harassment. These protections must remain and be expanded as the bill moves forward. Congressman McHenry's legislation would halt most program spending by first requiring Treasury to rescind and redo guidance, then requiring programs to make changes counter to best practices, and by prohibiting use of ERA funds for needed staffing or technology. The bill would ensure that the needs of many landlords and renters go unmet. There are proven and simple ways for ERA programs to expedite assistance. Hire staff, do robust outreach, simplify applications, use self-attestation, provide direct-to-tenant assistance. The best programs are already doing this. Those that aren't should course correct, as Texas, California, New York, and Connecticut have done, and as South Carolina and Arkansas announced recently they will do. For those that don't or won't, both the Biden administration and Congress should require these improvements. Thank you again for the opportunity to testify. I look forward to your questions.
Thank you very much, Ms. Yentel. We will now go to Mr. Winn. You are now recognized for 5 minutes to present your oral testimony.
Good afternoon, Chairman Waters, Ranking Member McHenry, and members of the committee. It is my privilege to appear before you today to speak on behalf of our organization, Winn Companies, and the more than 300,000 residents who call our apartment communities home. Thank you for this invitation. My name is Gilbert Winn, and I'm the CEO of Winn, a developer, owner, and manager of multifamily housing founded in Boston 50 years ago. Winn Companies is the largest operator of affordable housing and the 6th largest multifamily operator of housing in the country. We manage over 600 rental communities on behalf of a diverse range of clients, private owners of all types, nonprofit groups, community development corporations, tenant-owned affordable co-ops, and even public housing authorities. We manage mixed income communities with local housing programs or federal programs like Section 8 or low-income housing tax credits. We manage naturally occurring affordable housing as well. We also manage more than 10,000 unrestricted market rate units. Winn Companies works in 23 states in diverse geographies from the Northeast to the South to the West. Our company is also one of the nation's largest providers of housing-based community services. Why is this background important? Because it illustrates that we bring an informed, firsthand perspective covering nearly all constituencies of what is and what isn't working on the ground when it comes to emergency rental assistance and the goals generally of housing stability and eviction diversion. As both an owner and operator, we play a direct role on the ground in fulfilling the dual intent of the ERAP program, which is both to assist renters and to assist landlords. Today, I will first talk about our housing stability goals and the fundamental importance of rent collection in that endeavor. I'll then detail the specific successes and challenges we faced in accessing the ERAP program. And I'll conclude with our proposed revisions that we think should be urgently implemented to make it more efficient. While we are here to discuss the ERAP program, we all understand that it is but one component of housing stability. In early 2020, Winn Companies launched a holistic national housing stability program. The goal was to reduce non-payment rent evictions by 50% across our portfolio through a combination of upstream, consistent interventions. The result is that Winn Companies has had 0 evictions for non-payment of rent since the start of the pandemic. These results and our program have been recognized by my fellow witnesses here at NMHC and the National Low-Income Housing Coalition. As we are all gathered here today, it should be no surprise that emergency rental assistance is the single most important component of that housing stability program in avoiding evictions. We know this from experience. And we applaud this committee in recognizing the need for reforms. We understand that this $46 billion program was designed to assist both tenants and owners. This is not a choice between renters and profits. Rent is fundamental to the ability of our company and our clients, particularly our nonprofit owners, to operate and maintain existing apartment communities and to build affordable housing in the future. It's a virtuous ecosystem. In addition to mortgage payments and real estate taxes, as rent goes uncollected, variable operating costs that affect everybody's quality of life must be decreased, such as preventative maintenance, landscaping, security, trash pickup, and resident services. Staff hours at each property are cut if this happens, which means the paychecks of frontline workers are decreased. All in all, I am very proud of how the multifamily industry has stepped up during this pandemic. The vast majority of owners and operators are on the front lines, keeping homes safe and occupied. Now, in terms of ERAD, we have expended tremendous time, effort, and resources in order to make the rollout of the program as successful as possible. We've participated in 20 working groups across the country to design and administer the funds. We've participated in forums held by the apartment industry and the legal services community. At the state level, we have worked with leadership to address program glitches and portals and application processes. At the local level, we helped convene our peers to share best practices. We've held 54 separate 2-hour trainings to walk our team members through every step of their area's individual ERA processes. In terms of tenant communication and partnership, we've established contacts with administrative teams, created marketing materials, and began a near constant tenant outreach campaign in every apartment community, including engaging with local churches, schools, youth organizations, and
When
employers.
your time has expired. Thank you very much for your testimony. I now recognize myself for 5 minutes for questions. Mr. Schwartz and Ms. Yentel, I'm troubled by the number of landlords as well as renters who remain unaware of the availability of rental assistance. According to the Urban Institute, more than half of renters and 40% of landlords are still unaware of federal assistance. I'd like to share with you a little story about something that I was involved in just a week or so ago. I know a landlord with 5,000 units. I went to him to ask him what was going on with his rental units. He said to me only 40% of his rental unit, of his renters had applied. And I asked him, why was that? He said he did not know. And then I asked him, have you ever thought about using your community rooms with a person or persons and a computer or so to invite your renters to come to get assistance in applying for rental assistance? He said, no, they had not done that. I went a step further. I called legal aid. I put them together and I taught him how to do the notices to pin to the doors to let people know that assistance was available now in the community area of one of the largest of his unit, of his complexes, for them to come. On the first day, 90 renters showed up. Legal aid showed up with organizers and 1 or 2 lawyers, and they assisted everybody that came that day in applying for rental assistance. Now, you talk about a lot about what you've done, Mr. Winn. Have you seen anything like the operation that I just described to you? Mr. Winn? Are you unmuted?
Oh, I'm sorry.
Mr. Winn, have you seen anything like the operation I just described to you? Or did you hear me at all?
I'm sorry, Chairman. Can you repeat
Okay.
that?
Anyone else like to respond to that, Ms. Yentel?
Yes, Chairwoman Waters, thank you. I have seen some communities doing that kind of robust and equitable outreach that you mentioned. That's exactly the kind of outreach that's needed in local communities. But there are many communities where that is not happening. And as you say, we are seeing a significant number of both landlords and tenants not being aware that emergency rental assistance is available in their communities or not knowing how to access it. So this could be a result of language barriers. It could be challenges with barriers of access to technology. It could be simply that the education, the outreach is not happening. So we urge for program administrators to work with community-based organizations who have trusted relationships in some of the more marginalized communities where some of the greatest
All
needs
right, Ms. Yentel, I thank you very much. I want to move on to Mr. Schwartz. have you seen the kind of operation that I just described to you, where the landlords use their community rooms or their space to invite in the renters with notices that they put on their door, and then they get the assistance? I added to it legal aid because I brought legal aid in to do it, but I think the landlords ought to be thinking about doing it. What do you think?
Yes, with our own experience, and I know our peers, other operators in our industry are opening up our business centers. The people in most need, the lowest income, may not have access to computers or Wi-Fi. The application process is very cumbersome. In your state of California, there's 18 pages of manual input, and it's very complex. A lot of our residents only speak Spanish, and a lot of the forms are only in English, so we have to bring bilingual employees on our team to help them translate it. So a lot of the forms or the websites require downloading paperwork like proof of loss of job or paycheck stubs. No, a lot of the residents don't have scanners, so that we have to help them scan it into the system. So look, we're all motivated as landlords to assist our residents because we benefit from the ERAP as much as they do. But the system is so cumbersome that it involves a lot of man hours, and our industry is doing a great job shouldering that.
Thank you very much, Mr. Schwartz. Do you think the self-attestations will help? And this is something we've worked very closely with the Treasury on. You think that will help?
Absolutely. We're big proponents of it. You know, with the respect to proof of tenancy, where they don't have to download a copy of a lease. That's hard for a lot of our residents. Housing instability, self-attestation, income, you know, which means you'd have to download a paycheck stub. All these are barriers and slow the system down.
Thank you very much, Mr. Schwartz. I'm sorry your time is up. And now I will go to the gentleman from North Carolina, Mr. McHenry, who is the ranking member of the committee. You're now recognized for 5 minutes, Mr. McHenry.
Thank you, Madam Chair. Last December, Congress enacted the rental assistance, the rental emergency assistance program in a bipartisan way. And then in March, the Democrats did their partisan bill and had a new rental assistance program. We have two separate rental assistance programs at this point. And Treasury has a set of rules that are different on implementing these programs. So, you know, my question to you, Mr. Winn, is given how disastrous the rollout has been and the slow spending rates of getting money out the door to help renters, do you think it's better to combine these programs, number one? And number two, do you think the focus on getting people's back rent paid should be the primary view of the primary goal of the program?
Yeah, yes, I agree on both. I think the consolidation of the programs will remove a lot of busy work and a lot of uncertainty for both the landlords and the residents. Also, the point of back rent is critical. A lot of landlords don't wish to participate in the program if they're only getting paid for the current delinquency. If somebody moved out and they can't get paid for that past delinquency, they're not going to be utilizing the program. And that is in fact what's been happening. There are many residents who, when it comes time, are leaving with unpaid balances and not able to complete applications.
So, Ms. Yentel, under this bill, HR 5196, I would ask how imposing both new regulatory and statutory conditions on landlords actually speeds up assistance to renters.
There are many ways that Chairwoman Waters' legislation would speed up assistance: by requiring self-attestation, by requiring direct-to-tenant assistance, by getting at the root causes of slow ERA spending.
So
unfortunately,
how is that different? Direct to renter assistance? How is that different now than under this new bill?
It's currently optional, and only 28% of programs utilize it. So when landlords refuse to participate, the majority of programs close
under this bill, Ms. Yentel, under 5196, how, how do you encourage landlords to participate when you're providing, putting in place new hoops to get money that they're legally owed? How does that actually help?
The only place where new hoops, as you call it, are put in place, I would call them essential protections for tenants, are where we're changing the program to allow for direct to landlord assistance without any tenant involvement at all. These protections are essential to
Okay, but that's one
limit
change.
fraud and to limit tenant harassment.
So how about another change here? The bill requires grantees to provide information to renters on how to sue a landlord if the landlord follows the rules and receives the assistance on their behalf. How does that actually encourage landlords to participate?
No, it doesn't at all. What the legislation would do, again, only in cases where we're changing the program to allow landlords to receive assistance without any tenant involvement at all, it would require assurances that the landlord is using those resources to pay the arrears that are owed, and the tenant is no longer responsible for those arrears.
So what
It
you're
would
saying is
require
providing
assurances.
information on filing complaints against landlords helps expedite the distribution of assistance to households and families? Is that what you're saying?
What I am saying is that in cases where we change a program and allow for a landlord to receive assistance without the essential protection of tenant involvement in that application, that there be protections for those tenants and that there be protections against fraud.
And so in the real world, landlords would think this is a great new program to participate in, to encourage the people renting from them to sue them. So, Ms. Yentel, but I know you've been have a significant involvement with my Democrat colleagues on housing. Were you or any of your staff involved in the technical drafting of HR 5196?
In the technical drafting of it, no, that's certainly not our job. We've advised Chairwoman Waters and
Advised.
staff about
Sure.
recommendations.
Okay. And as president and CEO of your organization, I'm curious if your organization stands to benefit financially if this bill is enacted.
Not
Would
at all.
you, would
No.
your organization would not receive any dollars under Section 6 of this bill?
I can't speak to what Section 6 is off the top of my head, but we receive zero federal funding. We have no federal contracts. We don't contract with states or localities.
It is not a contract, and under this bill, it would change to nonprofit entities that primarily provide housing services. They would be eligible for these monies. And
Who would
so
be
I would just
eligible,
raise
as
this as
we
a question:
recommended it?
if you've testified that you'll not receive a dime under this bill, we'll make sure that we note that in the record. So with that, Madam Chair, I'll yield back.
Thank you very much. Let us remember, the centerpiece of this program is such that it allows landlords for the first time to be able to apply for the rental assistance, and they have 10 days by which to notify the tenant, and they can talk in that time, and maybe during that time, the renter will say, well, I'll do it, but this
Madam
is the
Chair,
first
is
time
this your
we
time or
deal
my
with the
time?
landlords.
Is
With
this your
that,
time or my
we will
time to
move
debate?
on, and Ms. Maloney, you are now, who is the chair of the House Committee on Oversight and Reform. You're now recognized for 5 minutes.
Thank you. Thank you all for your testimony today, and thank you, Chairwoman Waters, for holding this timely and very important hearing. As we've discussed, Congress provided nearly $50 billion in December and in the American Rescue Plan to help residents stay safely housed and to be able to afford their rent. This was necessary relief, 100% essential, not just for the health and safety of these residents during a pandemic, but a mass eviction crisis would have inflicted needless damage to our economy and to our families. Last week, Governor Hochul signed into law additional protections for New York residents and included new resources for landlords and tenants to access rental assistance. New York law also extended the state eviction moratorium until January 15th. It is no secret that the rollout of the rental assistance programs hasn't gone as smoothly as Congress would have wanted, which is why I'm so glad we have a great panel to hear about your experiences and ways we can further improve and streamline the program to better serve renters and landlords alike. One of the issues I've been hearing about from my constituents is the dual nature of the application. In effect, you need both the landlord and the tenant to complete the application to receive assistance. Specifically, I've heard from constituents that many have tried seeking assistance, but that their landlords were not willing to apply. And I know the reverse has also been true. So I'd like to ask Mr. Morris, we'll start with you. You're on the front lines helping tenants with this program. Is this an issue you're seeing in Philadelphia with the tenants you're assisting? Please tell us.
Thank you for that question. It has presented as an issue. There are two portions to the application. There's the landlord application and the tenant application. If a landlord applies on behalf of a tenant, it generates an affidavit that the tenant has to sign. I do believe that creating the additional flexibility where the landlord would not need to go to the tenant to get that affidavit signed and then submitted will allow that landlord to get a direct payment themselves once they have made the necessary efforts to inform their tenants that the program exists and get them to apply for funding. But it has been an issue.
Thank you. Ms. Yentel, can you add or can you speak to how this issue presents a problem, if it does, for tenants seeking assistance, and how the bill introduced by Chairman Waters would help address this problem? Ms.
Yes,
Yentel.
thank you. Thank you. Requiring a landlord requiring a program to have both a landlord and a tenant involvement when getting emergency rental assistance provides important safeguards against fraud and against tenant harassment, really important safeguards for the tenant. We have heard cases where tenants are not able to complete their applications. And certainly there have been cases where landlords have been refusing to accept emergency rental assistance when the application is approved and the money is presented to them. So the solutions on incomplete applications by tenants comes back to simplifying applications, using self-attestation wherever possible, and requiring that all programs do these actions. On the landlord side, where there's a whole variety of reasons why landlords seem to be refusing to participate, a solution to many of those challenges is to provide the assistance directly to the tenant so that the tenant can pay the rent and the landlord, if they don't want to be involved in a government program, doesn't have to be involved at all. Only 28% of programs are currently using direct-to-tenant assistance explicitly, and all should be required to use this essential safeguard, as would happen under Chairwoman Waters' legislation.
Well, thank you. My time is almost expired. I yield back, and I thank you, Chairwoman Waters, for your leadership on this important program. We're working very, very hard to implement it on the ground across the country. Thank you. I yield back.
Thank you very much. The gentlewoman from Missouri, Ms. Wagner, is now recognized for 5 minutes.
Well, I thank you, Madam Chairwoman, but we're not working very hard to get this administered because you know what? The money's not getting out the door to the people that need it after months and months and months and months. For far too long, struggling Americans, both renters and landlords in Missouri's 2nd Congressional District and beyond, have not received the assistance that Congress authorized. From what little data, I think the last was in July, that Treasury provided us, since Congress has approved nearly $50 billion in rental assistance, only $4.8 billion or 10% of these funds have made it into the hands of those who need it most. It is clear to the American people that the Biden administration has failed to distribute billions in rental assistance. Months ago, Republicans introduced legislation to streamline, to cut through the bureaucratic red tape, to streamline this rental assistance program to get this money out the door to support hardworking Americans. However, Democrat leadership completely ignored this good faith effort. And I think it is critical that Treasury Secretary Yellen take responsibility for the program's failure and appear before this committee, as we have requested on several occasions, to no avail, so that we can better understand what is keeping so many of America's tenants and landlords from receiving these funds in a timely manner. Instead of working in a bipartisan fashion and incorporating the much needed provision of Ranking Member McHenry's legislation, Democrats have been trying to shove through a bill in the 11th hour that is full of bureaucratic red tape without any input from across the aisle and are needlessly putting families at risk of eviction and pushing mom and pop landlords out of business. We are not helping renters and we are actively hurting landlords. Mr. Schwartz, Mr. Winn, COVID hit in March of 2020, which was 18 complete rent cycles ago. This means there may be some landlords who have not been paid a full month's rent in a year and a half. Oh, what have been the financial impact that COVID has on landlords to date? Mr. Winn.
So, thank you for that question. So currently there are $37 million in accounts receivable and delinquency rents across our portfolio. Despite all the efforts I testified about that we've done, only half of the residents have actually received the funding that they're eligible for. And the tenant consent aspect of that, we feel, is the largest barrier. We have done the communication. We have met with them. We've filled out the applications. We've handed them the complete applications. And yet 15,000 of our residents who are eligible have not received the assistance.
And yet we are sitting on over $40 billion, much of which was in the CARES Act back in last December, that is still sitting there in this fund, not distributed. It is disgraceful. What incentives do you think, Mr. Winn, would make a meaningful impact in helping to deliver this emergency rental assistance to repay those debts?
Very quickly, it would be informed consent as opposed to signatures by the tenant, so that landlords can apply on behalf. It would be bulk applications that landlords are able to submit and that are mandated to be approved by the ERAP administrators rather than just encouraged. A combining of the two programs to cut out bureaucracy. And I would say really the fourth one would be to make sure that when a unit is vacated, that unit is still eligible for rental assistance, because that is where a lot of the outstanding delinquencies are.
You know, thank you. The December effort, which was a bipartisan CARES Act to get the money to eligible households quickly and efficiently, was hastily undone with the creation of the Democrats' Emergency Rental Assistance 2 program in March. And the Dems bill, that $1.9 trillion bill, was a second parallel program with similar purposes, but different rules, timelines, and incentives. And most of all, what's most egregious, it pushed the end date of the Biden administration's mismanaged program out to 2025. 2025. We need rental assistance now, not in 2025. We have got to fix this broken bureaucratic problem and come together, Madam Chairwoman. I yield back my time.
The gentle lady's time has expired. Mr. Sherman, it's time for you, who is also the chair of the Subcommittee on Investor Protection and Entrepreneurship and Capital Markets, to now be recognized for 5 minutes. Let's get beyond political talking points. Let's legislate.
Absolutely. I think this is the hearing we should have, not a theatrical hearing where we bring in big names and what we need is people who are on the ground who can help get this program to work better. That being said, this program is not the best example of government working together to help people. And those of us who want government to help people in need bear the rhetorical burden of showing that government can be effective. It is an emergency program, and an emergency program is one where you're trying to build the plane while you're flying. So it's not that easy to put something together in an emergency, but we should have done better. And I think with this hearing, we will. Mr. Schwartz, perhaps briefly, you could tell us what are the impediments faced by property owners when trying to utilize the emergency rental assistance program that have led some owners not to even participate in the program?
Yeah, we've talked about one of them, which is owners would like to participate, but the resident doesn't want to participate. And so having that ability to apply on behalf of the resident is super important. Also, what we have seen is strings attached. Like additional moratoriums that you accept assistance, but you're subject to a new moratorium. Landlords are very reluctant to sign up for more strings attached to accepting the assistance. Another one is debt cancellation, where you receive assistance that is below what you're owed, and that it settles the debt. So we don't want to add barriers, and those are two things that are in this bill that we think will make landlords reluctant to participate in the program. And the best solution to solving this is getting the ERAP dollars in the hands of the residents and the landlords.
I think also this crisis will determine whether other people get involved in investing in building new apartment buildings, to put people in a position where they have to pay the mortgage and they can't collect the rent is not going to encourage people to go into this business. Ms. Yentel, we've got almost half the renters in this country paying more than 30% of their income on rent. We need to build 328,000 new apartments every year. We're not even close to that. The COVID crisis has slowed construction. What policies would you suggest to create an environment that incentivizes additional housing development and the preservation of housing we have now?
Sure, you're absolutely right that the pandemic exacerbated a pre-existing affordable housing crisis. Many of the same renters who struggled to pay the rent, to keep up with rent during the pandemic, struggled pre-pandemic, and they'll continue to struggle post-pandemic unless and until Congress invests in the long-term sustained solutions to really build a housing social safety net in our country. And many of the investments that are included in the reconciliation bill that Chairwoman Waters released are the kind of investments that are needed. A major expansion of rental assistance to preserve our country's public housing infrastructure, to build more apartments affordable to lowest income people through the National Housing Trust Fund, and to incentivize or require local governments to reduce or eliminate restrictive local zoning that inhibits the supply of any kind of apartments, and especially affordable apartments, and drives up costs for everyone.
Everybody's for more apartments, but not near them. It is a problem that local government faces. Mr. Schwartz, many owners from large to small have been carrying these rental balances that they haven't collected. They still have to pay their mortgages, et cetera. What does that ultimately mean for the solvency of property owners, their ability to continue to be in the rental housing business? And should we be concerned about the overall market and systemic effects?
Yes, we should be concerned. There have been no reciprocal moratoriums with property tax bills, garbage collection bills. Those are all due in full. And so the solution to that is the ERAP, and getting that in the hands of the landlords, because there is financial distress. And we've seen it the most with smaller landlords who can't pay their bills.
Mr. Schwartz, your time has expired. The gentleman from Texas,
Thank you.
Mr. Sessions, is now recognized for 5 minutes.
Madam Chairwoman, thank you very much. And the opportunity to have our witnesses here today is appreciated. Mr. Morris, I'd like to perhaps engage you first, if I could, please. The legislation, when it passes Congress, is given to an administration who then offers and makes the legislation conform to their ability to offer guidance for things to work the way the legislation is designed. Can you please tell me your working relationship on a local basis with those the administration people, whether it be in HUD or whether it be in Treasury, about the guidance that you've received and what feedback you've given back to them. And the reason why I'm asking this is because we have no one from the administration who can defend themselves on this. And so I'm interested in your answers about that guidance and what you've told them back about making this work better.
So at least from the perspective of rental assistance here in Philadelphia, there was an existing Philadelphia eviction prevention project that had been working on these issues from at least 2017. So when the pandemic hit, we started engaging both our local city council and state legislative leaders and the Pennsylvania Housing Finance Authority, who had the first round of rental assistance, on making the program more effective, eliminating barriers that would basically discourage participation. So we have been involved in that process through and through. And at least in building out rental assistance, every time an issue is brought forward to us by tenants or landlords who we engage with, we provide that feedback to the agency and see how we can address that. Self-attestation has been a major issue, and we've gotten to the place where landlords or landlords councils can now provide letters to agencies that verify tenancies and show how much is owed without additional barriers being put in place. So we've been working in constant communication with our local representatives to try and improve the program every step of the way.
Mr. Morris, is your there in your locality in Pennsylvania, were you given the flexibility to amend what we have heard would be the paperwork that we heard in California is not anything but in English? Were you given that authority and responsibility ahead of time, or to change that, or was that just part of the bill that said only provide this in English for the application?
So I believe we were given that authority, and we also requested additional guidance from the federal government through Treasury for additional flexibility about how we administer the program. So we are in constant communication to make those flexibilities happen. I believe just generally in terms of language access, we're required to provide the application in more than English. We also work with neighborhood action councils to make sure that there's an agency out in the community that can target individuals or create another location where someone can go and apply and get that assisted.
Yes, and thank you. And Mr. Morris, perhaps you're providing the feedback today to us, which is why not only Mr. McHenry, but also Mrs. Wagner are saying that we believe that what should have happened today is we actually heard from the program administrators about the flexibility that they are providing across the country and following the federal law when they see, for instance, in California, where the applications are in English only, as the testimony today was given to us. And this is disturbing to us because in the state of Texas, and I'm sure that what has happened is Mrs. Yentel's feedback helps us to see who is successful, and there are characteristics of success that the administration would see, or those administering these programs, and then to know specifically what they were doing from receiving feedback after they see perhaps those that were more effective than others. And Mr. Morris, I just want you to know that you and Ms. Yentel and Mr. Schwartz are providing us information, but we're interested in a follow-up on this. I am personally interested in what kind of success you're finding with feedback from the Treasury Department in making this work, and whether they actually are a hindrance or a help, whether they are attempting to provide you with the needed feedback that I would say that would come from the guidance that they would need to have and see from across the country. So, Madam Chairwoman, I would request that, as Mr. McHenry and Mrs. Wagner has suggested, that we need to dig down with information about providing the guidance from a national perspective of not only the Secretary of Treasury, but their feedback about how we would make this work. And I thank the gentlewoman, and I'll yield back my time.
Thank you. The gentleman from Texas, Mr. Green, who is the chair of the Subcommittee on Oversight and Investigations, is now recognized for 5 minutes.
Thank you, Madam Chair. Madam Chair, I'm very proud to associate myself with your legislation. Your legislation does what I have been calling for, and that is assure that the rent is paid. The tenants will have the opportunity to access funds, but also the landlords will have an opportunity to access these funds. And they can access funds for back rent. Some things bear repeating, Madam Chair. Landlords can access funds for back rent. I think this is exceedingly important for, yes, all landlords, but especially for the mom and pops who have had to bear the burden of maintaining property over so many months now. So I proudly associate myself with this program and would thank you for also looking into how we can inform people. A good many of the people I represent are not knowledgeable about programs. This program that you're providing now, this legislation would inform people of what is available to them. I think this is most beneficial. And finally, the landlords will have an opportunity to not only get back rent, but rent for some time out into the future. The total sum of months can be up to 24 months. So this is an outstanding program. I would like to, if I may, Madam Chair, mention one additional thing. There are many people who are still suffering as a result of CDBG DR funds that have not been properly allocated. And Ms. Yentel has some knowledge of what's going on with CDBG-DR because she happens to be associated with some 800 national, state, and local organizations calling for codification of a program. So Ms. Yentel, I'd like to yield time to you to explain why there is such broad support for the codification of CDBG-DR into a statute at this time.
Sure. Thank you, Congressman Green. The CDBG Disaster Recovery Grant Program is one of the most essential resources that communities receive after disasters. But the program is not permanently authorized. So that means that every time there's a disaster, it needs to be reauthorized essentially through the appropriations bills, the supplemental bills that provide funding. This slows down the process pretty significantly of getting resources to communities. And it means that very often the rules for the program get rewritten each time, creating a lot of uncertainty. Local communities, when what they most need is certainty and money to start helping people repair and get back on their feet after disasters. So the Reforming Disaster Recovery Act, your legislation, would permanently authorize the bill, which would in and of itself mean resources would reach communities faster. It would also require data sharing across programs, which would help to identify gaps in needs and ensure that those are being met. And it would allow for much greater public participation in disaster recovery efforts. Altogether, it could help to lead to more equitable and complete disaster housing recovery in communities hit by natural disasters.
A second question for you.
Excuse me, Mr. Green, if I may jump in on that, Mr. Green, I'm so sorry to interrupt you.
I will yield to you.
Thank you so much, Mr. Green. I just needed to note that the residents of Oregon are still waiting for disaster recovery dollars from last year's historic and tragic wildfires. So I just wanted to lend my support to Ms. Yentel's statement.
Well, let me extend my sympathies to the people that you represent, as well as the people in Texas, people that I represent. We have a similar circumstance, and I believe Mr. Cleaver would attest to a circumstance that he's having to negotiate as well. But let me just ask this of you, Ms. Salazar, since you are now speaking to me, this self-attestation, this seems to be pretty important. And it seems to be something that the Congresswoman, the chairwoman, has placed in this legislation. Explain how important the self-attestation is.
Thank you so much, Mr. Green. You are absolutely right that tenant self-attestation has proven to be incredibly helpful to expedite the delivery of rental assistance. I will also note that it is a big shift for many program administrators who are charged with the important work of preventing fraud and running these programs with federal and state and local oversight. And so that's why we are supportive of the safe harbor provision in Chairwoman Waters' legislation that would provide that assurance to program administrators that self-attestation is appropriate, useful, and encouraged in the program.
Thank you, Madam Chair. As I yield back, on a scale of 1 to 10, I would give your program, your legislation, an 11. I yield back.
Thank you, Mr. Green. The gentleman from Florida, Mr. Posey, is now recognized for 5 minutes.
Thank you, Chairwoman Waters. Mr. Winn, you were talking about your outreach, I guess, through some church groups and stuff in your opening statement, and you got cut off. If you'd like to finish it up now, I'd like to be proud to give you the time.
I appreciate that, Rep. And I will do that. So despite all of that outreach, these are the statistics. To date, Winn Companies has been able to work with 15,000 households to apply for $22 million of ERAP support. Of this amount, 17 million has been formally approved. And I recount all of our efforts, not to boast about what we did, but to make the point that despite all these Herculean efforts that a company of our size can actually perform, we still have 15,000 additional households who are eligible for ERAP financial support, but who have not yet participated because of program inefficiencies. It leads me to conclude that smaller landlords, without the possibility of resources that we enjoy, must find themselves in an even more untenable and a more unfair position. It leads to the conclusion that something needs to change. Despite our efforts, we, as I mentioned, and our clients are still carrying $37 million in delinquent rent. Within that universe of households, 2,400 households who are eligible for the assistance otherwise are not able to participate because of more restrictive income guidelines in certain states. On top of this is the 15,000 eligible households that I mentioned who are non-communicative despite our best efforts, and for good reasons and for understandable reasons. Traumatized by medical or financial hardships, language barriers, sometimes fearing insurmountable rental delinquencies, technology barriers. Some are confused by mixed messaging on eviction moratorium. Some simply just don't trust the system. Regardless, the unfortunate result is that too many of the very folks that the ERA programs seek to help are those who are not benefiting from the program. So the real world solutions are the direct tenant applications with informed consent for the to the tenants for 10 days. But we also believe there shouldn't be additional restrictions placed on that without matching funding. Said differently, if there were to be an agreement that if you take these funds, you have to stably house residents for 120 more days, we ask for a requirement as rather than a suggestion that rental assistance funds be made available to match that obligation. We also want to make sure that this happens so it's not a major deterrent for landlords across the country to enter into what is otherwise a great program. We should mandate the allowance of landlords to directly apply to for funds, and make sure that those are processed quickly. We want to make sure that the programs are combined and that the eligibility is raised to 24 months rather than 18 months. And we want to make sure that there is an implementation mandate for bulk applications by landlords rather than just the allowance of it, because we have seen across the states we work in that many of the ERAP administrators will not allow bulk applications, even though it's permitted by the legislation. I just want to end by saying that I believe that the work of this committee has been excellent. I believe these amendments are required. I don't believe this is a political issue. I believe this is a practical issue. And if we can reach more people, we're all better for it.
Thank you.
Mr. Posey, Mr. Posey, if I may just add to that really briefly, while I support all of the proposed changes that Mr. Winn has just highlighted, I think it is critical that tenants are informed, as the bill proposes to do, that something has been done on their behalf so that they can govern themselves accordingly and that the landlord-tenant relationship can be preserved on a forward-going basis. Thank you.
Any other witness want to weigh in on this thing? I've just asked, wondered from the beginning, even mentioned at the last hearing, why we wouldn't turn to the Department of Housing and Urban Development that has a network in place already to do this stuff to deliver assistance. You know, I wonder why we would create a new program in the Treasury to distribute rental assistance through a network of guarantees that are yet to be put in place. I mean, if we were going to start giving out free petroleum, I think the place to start would be through existing gas stations. And I see my time has expired. I yield back. Thank you, Madam Chair.
Thank you very much. The gentleman from Missouri, Mr. Cleaver, is now recognized for 5 minutes. Mr. Cleaver is the chair of the Subcommittee on Housing, Community Development, and Insurance.
First of all, thank you, Madam Chair, for introducing this legislation that is desperately needed. Mr. Morris, in your statement, you made there's a part in there that I think everybody should make sure that they focus on, and it's you say something like all around the country, tenants and landlords are experiencing widespread delays in processing a rental assistance application, and you go on to talk about the number of people in Philadelphia whose applications have not been processed, and so forth. Yeah, you remember that statement? I mean, are you conversing that statement that you?
Yeah. Yeah.
Okay. The reason I want to focus on that is I think what you're suggesting, and very strongly, I think, and it fits in with what we're doing here, that, you know, we've got to reduce the delays, you know, all of the barriers. And one of them, I think, my experience is that the cities are trying to get the money out the door, but you've got to make sure that the grantees and their partners are able to complete the application process. And sometimes that's a challenge. I think you may or may not agree, but you know, anything that we can do to help get the money out of the door, including in some instances, for example, maybe getting the Hispanic chamber, the Black chamber, the Asian chambers, all working to help interpret the application process to people. Here in Kansas City, we've run into people who, I didn't understand that. I don't know how to do this. Or in one case, one of my staffs had a huge meeting, and somebody said, well, I didn't apply because I didn't know I was supposed to apply. Or I thought somebody would apply. I mean, should not we do everything possible to make sure that, I think you had 55,000 or more, I don't know remember the exact number, of unprocessed applications. Do you think that there are some things that we should include or in this legislation that I think is absolute necessity if we're going to get this program running at the optimum level? So what do you think, sir? What say you?
So there are a few things that I would say, at least in the context of Philadelphia. We've already spent 85% of our ERAP fundings over several allocations. So there is the need for more money to flow into the city to address those applications that are still yet to be processed. And that is a significant financial constraint that the program is going to face. In addition to that, making the program more flexible through self-attestation, which we've already talked about. I believe the first version of rental assistance required income to be verified through the Department of Labor on a federal level, which created significant delays. So a lot of that money was not spent in a meaningful way. So to the extent that we can eliminate those barriers and that additional paperwork and create an additional sites and points for people to interact with the program, outreach is going to be very critical in this process. And the best way to reach people is communities where they are. And that might require that programs invest in having someone go out to apartment complexes and inform them that there is a process available for you to apply. It might involve putting mailers in, digital mailers in everyone's inbox, because most landlords use portals to communicate with their clients their tenants at this point in time. So there's a lot that can be done in terms of outreach, and there should be a kind of a no wrong door policy. If someone shows up to apply, they should be assisted. And documents are harder to get at this point in time because a lot of the federal agencies, the Department of Human Services, Social Security, all of those agencies are now remote. So getting paperwork is a significant barrier to tenants, which leads to delays on the side for landlords. So to the extent that we can eliminate any red tape and make it easier for both parties to apply and no one gets turned away, and any lapse of information is not necessarily held against a tenant or a landlord, that is the best way to go forward, make the program easier to use and not harder.
Thank you very much. Very quickly, you know, and it's in the language of our legislation, not this legislation, but the overall legislation, that municipalities can, you know, eliminate some of the normal requirements in order to get this out quickly. Many cities, including my own, I think, you know, they and you can't expect one of the, you know, the head of a department to do something and later to be criticized for it. So they end up saying, okay, we need a 60-day period for a response to an RFP or something. There's got to be a way that we get the word to all of the municipalities. Maybe the mayors need to be the ones who actually sign for the participation in this program, so they can understand that the regular processes are relaxed in order to get the money out quickly.
Thank you so very much. Thank you, Mr. Cleaver. Your
You got
time
a
has
13. It's a 13 from my perspective. Mr. Green didn't go high enough. It's a 13.
Thank you so very much. Mr. Heisinger, you're now recognized for 5 minutes.
Thank you, Madam Chair, and I appreciate my my friend, Mr. Cleaver, getting into some substance of these bills. And I do want to commend the chair for attempting to deal with some issues that we have some mutual concern in. And I want to start off with what I think are some unified views of some of the problems. We all agree that in 2020, when Congress appropriated this money for the ERA 1, it was to eliminate rental arrears accumulated by COVID-impacted low-income households. And then there was, of course, the additional $21.55 billion in ERA 2 in March of 2021. I think we actually all pretty much agree as well that there was a failure to get money out the door that not only put renters at risk of eviction, but it also hurt mom and pop landlords and who are more likely to own and operate affordable rental units. The other thing I think that is pretty unifying is that Treasury, we all understand Treasury has failed to responsibly administer more than the $46 billion of Congress appointed funds and to eliminate these arrears. That's why we're sort of in this spot. Here's where maybe we diverge and we don't agree as much. Many of us view that the changes made in this program by the Biden administration actually may have punished landlords and frankly scared many of them out of the programs. Many of us also believe that Secretary Yellen has failed to take responsibility for the program's failures and shortcomings, disregarding requests to have opportunities to have these questions addressed to her by this committee and by others, and by allowing her to bypass the statutory obligations to testify. And frankly, many of us believe that instead of fixing the program, the proposed changes would create even more bureaucracy, add new burdens, and will scare off more landlords, steer funds away from COVID-impacted low-income households, and remove protections to combat fraud. Now, I understand that there is a real need that we all have to deal with this, and I will take the chair's request to say that we need to legislate. I will note that I can see if the Trump administration had so badly bungled this program, there would be a natural desire of my friends on the other side to hold them accountable. And that's what we are here trying to do with the Biden administration. So Um, let's talk a little bit about the bills themselves. And again, I commend the chair for addressing specifically the ability of landlords to go and get some remuneration when their tenants won't sign off. Now, here's the key: some remuneration. And in my view, I believe this has been a legal taking, right? The takings clause, the takings concept is you forced me to do something that legally I didn't have to do, but you forced me to do it. So there you need to owe me, and you owe me the obligation of what I legally own. Well, in the chair's particular bill, it requires landlords who submit applications without a signature of a tenant to accept any amount awarded to them as satisfaction of the entirety of the back rent debts owed back to March 2020. It requires landlords who accept assistance, including arrearages without renter consent, to agree to an individual 4-month eviction moratorium for that tenant beginning upon the date the assistance is received. So an additional 4 months. It binds landlords who has or does not accept assistance without renter consent to comply with, quote, any conditions, close quote, imposed by the secretary to ensure renters, quote, remain stably housed, close quote, with no end date for such conditions. It requires grantees to prioritize applications of tenants over those of landlords submitting with no applications. It requires landlords who receive assistance to, quote, set aside and vacate any past eviction order from an assisted tenant and to, quote, agree to seal any eviction filing, meaning it never happened. We can't acknowledge that. It removes accountability and protections that exist to combat fraud. Prohibits grantees from requiring applicants to submit proof of a written lease. It removes the tenant income verification by landlords. We kind of go on and on. And again, while I commend the other side for realizing we have an issue, it seems to me these handcuffs really are not going to get to that final goal and objective.
Thank you. Mr. Heisinger, your time has expired. Thank you so very much. The gentleman from Illinois, Mr. Foster, is now recognized for 5 minutes.
Am I audible and visible here?
Mr. Foster, we can hear you.
Oh, thank you. Mr. Morris, I was glad to learn that Philadelphia is proudly one of the cities that has legislated a right to counsel for tenants facing evictions. You know, this is obviously monumental in a city where over 90% of tenants facing evictions were legally unrepresented compared to 81% of landlords who typically have attorneys. So although the pandemic has cast an unforeseeable and incomparable skew on the success of such a program, I imagine that ensuring legal representation for tenants facing evictions would greatly reduce the level of unjust evictions or evictions in general. So, Mr. Morris, can you speak about the extreme importance of having legal representation in eviction cases? And more broadly, could you explain why organizations like Community Legal Services Inc. or the Legal Services Corporation nationally are vital to protecting marginalized people, especially during times like this?
Thank you for that question, and I'd be happy to. I think it is critical, especially now in the context of the COVID-19 pandemic, that tenants be informed of their rights and protections that exist in any sort of eviction case. Evictions have long-term consequences for tenants beyond just being displaced. If you displace a family, you displace a child out of school, you potentially displace an adult out of work, and you can trap a family in poverty for generations to come, because the cost of a forced move is both what you owe to the landlord that's evicting you, the cost of relocation and the cost of finding new housing, and any collateral consequences that come from being displaced in that period. To the extent that a tenant can be informed and given the ability to self-advocate just as a bare minimum, to know that you have rights as it relates to funds that have been received on your behalf. Your landlord has been paid and made whole, and you're allowed to stay. That is critical information that tenants otherwise often don't know unless they're connected with legal services or other representation. Sometimes there are city protections or ordinances that come into play that require landlords to meet certain standards of housing, just like minimum housing standards that tenants have to live in and then pay rent. If those standards are not being met, then a landlord should not be able to use the court to both collect rent and evict a tenant out of those types of housing units. And with the affordable housing crisis that is going on in the United States, it is critical now more than ever that tenants are equally as informed or have access to representation, because a courtroom is a traumatic place. You enter a courtroom where you know that you owe someone a debt. Your perspective is, I don't have the ability to pay this money, but I also have nowhere to go with me, my children, and everyone else in my household on a normal day. And then you add the pandemic to that, and that is significantly more of a pressing issue. And as has been shown, and I put in my testimony, the majority of people facing evictions in the city of Philadelphia are single parents, most predominantly Black and brown females who are already living in poverty, and the poverty is exacerbated by the loss of income. They're more likely to work in industries where there is sporadic unemployment, or these industries have been directly impacted by the pandemic. They're forced to be frontline workers or workers who are at a greater risk just by health morbidities for getting COVID-19 and taking that into their household, where they may have vulnerable family members. So the goal is always to empower tenants to be able to make decisions, and to the extent that we can balance the playing field and create greater flexibility for those tenants, that is always the goal. No one knows more than an individual who is.
Yeah, excuse me. So you'd consider that adequate funding for legal services corporations for the explicit purpose of assisting tenants during this sort of situation is really an essential element for ensuring fair housing infrastructure?
It is essential, and it is highly critical for the continued success of the rental assistance program, because someone has to be there to assist tenants in holding landlords accountable, not from the perspective of making sure that landlords can't use the court system, but making sure that they comply with any requirements that have been put in place that protect tenants and allow them to remain housed in the long term.
Yeah, and do you think that having an expectation of legal representation on both sides of an eviction dispute is likely also to be a useful gate in preventing fraud? Just that you have a lawyer who has his law license on the line if he aids and abets fraud. Are we likely to get a lot of the fraud concerns addressed that way as well?
I believe you will get a lot of the fraud concerns addressed that way, and you will avoid a tenant feeling unsure or unsafe about trying to communicate with their landlord with the threat of a large balance hanging over their head if they have an advocate that can stand with them and ensure their legal protections.
Thank you.
Very much, Mr. Foster. Your time has expired. The gentleman from Kentucky, Mr. Barr, is now recognized for 5 minutes.
Thank you, Madam Chair. And I would like to echo the sentiments of Ranking Member McHenry and some of my other colleagues that I am troubled that Secretary Yellen is not here to testify on this program. The majority invited Secretary Fudge to testify before the committee almost 2 months ago, which was somewhat informative, but gravely insufficient for the gravity of the situation. Here we are today with another hearing on the same topic to discuss why less than 11% of the funds appropriated by Congress almost a year ago have support of the funds appropriated by Congress almost a year ago have supported renters and landlords. Yet the responsible party remains absent from our witness lineup. Congress directed Treasury to be the primary steward of these funds and to operate the program in such a way that assists struggling renters and landlords. Yet despite her direct responsibility for this bungled operation, Secretary Yellen has not testified before this committee, and the majority has not even invited her to do so. While I'm sure our witnesses today will be able to provide some helpful insight, we do need answers from the ultimate decision maker and the party responsible for this total mess, and that is Secretary Yellen. Another preliminary comment, and this is maybe a different take from both my colleagues on my side of the aisle and the other side of the aisle. Yes, we need to expedite the emergency assistance. That's why Congress passed it. But I hear a lot of talk today in today's hearing about landlords, about tenants, and they have very important interests. But there's someone that nobody has been talking about here in this hearing, and that's the hardworking taxpayer and the taxpayers' sons and daughters and granddaughters and grandsons who are incurring mountains of debt with this exploding welfare state. And I think what we're really talking about and hearing about today is not just the incompetence of the Biden administration itself, but this program proves that big government welfare programs are ineffective and they are a recipe for waste, fraud, and abuse. The breathtaking incompetence that we see here, and the waste, and the delays, and the open invitation for fraud is a direct indictment of expansion of the federal welfare bureaucracy. Now, I want to ask Mr. Winn a question here. Feedback we have heard from landlords across the country, including small landlords who own only a handful of properties, suggests that the ERA programs are difficult to access because of bureaucratic red tape and preconditions that disincentivize participation. Mr. Winn, how can we improve the ERA programs to make them more accessible for small landlords? How might the changes under the majority's bill, which actually adds red tape for landlords, affect participation in the program?
So I believe that, as always, there's some solution in the middle. And I believe that the changes in the majority bill, by and large, can help as long as we're not also adding restrictions. So what I mean by that is the bulk application processes where a landlord can say, a small landlord can say, all of my 8 tenants can apply for assistance. I can submit as a landlord directly, self-attestation about things like income. That will greatly cut down on the red tape.
Yeah, I hear you, and I'm sympathetic to bulk applications and landlord applications. But again, I'm going to return to, and I want to expedite these funds. And you haven't heard this today from either side, any members on either side of the aisle. But I'm concerned about the taxpayer. And this self-attestation idea concerns me a lot. The taxpayer we're talking about nearly $50 billion, and we're going to just allow landlords and tenants to just self-attest without any documentation of income or job. We have 10.5 million unfilled job openings in America. And the reason is that we're paying people to not work. We're paying people to not work. We can't just continue to ask the taxpayers to subsidize people to live on the taxpayer's dime. Why can't we have just simple documentation, allow landlords to apply for tenants, but have some protections for taxpayers who are getting fleeced?
So I would say one of the aspects of the original bill are also audits that are allowed at the state or administrative level. So to your point of fraud, I think that if people are committing fraud, those audits hopefully will catch that.
Well, let me just say, in conclusion, the solution to the Biden administration's incompetence is not to dishonor taxpayers by making waste, fraud, and abuse in this program even easier. Taxpayers need to have confidence that the renters who can afford rent are not just taking advantage of this program, reducing funds available for those who actually are eligible and who actually are experiencing housing instability. And I think some of these reforms in the chairwoman's bill make fraud not just likely, but guaranteed. And with that, I yield back.
Thank you very much. Paying these landlords is not waste, it's not fraud, and it's not abuse. I will now call on Mr. Caston, the gentleman from Illinois, who is now recognized for 5 minutes.
Thank you, Madam Chair, and thank you to our witnesses. I must say I've learned a ton through this hearing, and I appreciate you all taking the time to do this. Some of my questions are about COVID specific, and some of them are sort of the broader sort of landlord-tenant issues that are going on. And Mr. Winn, I'd like to start with you, if I could. If I've heard you right, you said you have 37 million in accounts receivable delinquency on your books. I see you nodding. Okay, I'll take that as a yes. Help me understand, how much did that increase during COVID? How much were you carrying 18 months ago compared to the 37 million now?
So it's a good question. So they fluctuated. The 37 million that goes across our entire portfolio, including our clients, that has fluctuated. It is definitely higher post-COVID than it was pre-COVID. We've seen statistically about a 5% drop in rental receipts because of COVID. And that on a portfolio of 100,000 apartments can add up pretty quickly. One of the interesting things to note is that the average balance of a tenant in our portfolio is $1,400 of delinquency, which is interesting because it's a fairly low number, but that is also because of the affordable nature of our portfolio. I would imagine if someone's portfolio were skewed to the market, that probably doubles to about $3,000.
Dude, I seem to be frozen. Can you all hear me still?
You now.
Can you all still hear me?
Mr. Caston, you're on.
Sorry, we were frozen there for a second. So can you estimate, like, we talking like a 5% increase, a 10% increase? How much has it gone up during COVID? Just as a quick answer, if you could.
Yeah, and I can answer too from our portfolio's experience. But one thing I would say is our delinquency is about 3 times as high during COVID as it was before.
Okay.
So,
Well, so let me, since you picked up Schwartz, and I apologize for my IT issues here. How much of that are you carrying on your books? So when you borrow, you've got this asset on your books for whatever that receivable is. How much is either your bank or your auditor, how much are they typically writing that down? Are you carrying 80 cents on the dollar, 50 cents on the dollar? How much are they writing that off?
well, we have the job, our accounting department, of how much do we write off. We're being optimistic that we won't have to write much of it off because of emergency rental assistance. And so we're reluctant to write off that right now. But if we don't get the assistance, we will have to write that off.
Okay, so then Ms. Yentel, then speaking broadly beyond COVID, when particularly for low and moderate income tenants, let's say they get behind, they miss a payment, they've lost their job, and then they get back. How often are they able to come current, and how often are those tenants just sort of carrying that debt sort of in perpetuity, even though they're staying current on their rent?
Right. It's a really good and important question because many of the tenants who are behind on rent are very low or extremely low income. They were before the pandemic, during the pandemic, and will be after the pandemic. They are many of the frontline workers who initially lost their jobs or lost hours at work. They lost wages. They fell behind on rent. Even as they are employed now, it's difficult, even pre-pandemic. Many of them work at the lowest wage jobs. They're not able to make rent. They're certainly not able to pay back arrears that are owed without assistance. Many tenants during the pandemic made a lot of really difficult trade-offs. They borrowed money, they paid rent on their credit cards, they stopped buying store-bought food, which is why we saw such an increase in food pantries.
And I'm sorry to interrupt because I want to get just 2 more questions in and I'm running tight. Either Ms. Yentel or Mr. Morris, just quickly, can you comment, what does that impact have on their credit score? So if they're carrying this rent that they can't pay, even though they're staying current going forward, is that a permanent hit on their credit score? Are they forced to prepay utilities? What does that mean practically?
Yes, there are all kinds of harmful impacts that come both from carrying debt and having poor credit scores. It makes it more difficult for them to get loans that they might need in the future, to use credit cards again to pay for things that they don't have the cash for. And evictions as well are a single eviction filing on a tenant's rent record stays with them for years and harms their ability to get affordable housing.
I'm out of time, but as you can just tell, and I would welcome all of you to follow up, I'm trying to make this connection, and I don't know what this is, but for all of you on both sides of this, if the landlords are carrying bad debt that's affecting their ability to get credit, and the tenants are carrying credit scores that are hurting their ability to get credit, how do we bridge that gap from a policy perspective? And welcome following up with you. Thank you very much. I yield back.
Thank you very much. The gentleman from Texas, Mr. Williams, is now recognized for 5 minutes.
Thank you, Madam Chair. I want to thank all of you for coming here today and answering all of these questions. And I can tell you that every landlord I talk to, this pot of money has been frustrated with how slow it has been getting to people in need. As much as we need to ensure that renters are taken care of, we cannot forget the landlords. Also, they have financial obligations to handle as well. This money could be a lifeline, but so far it has failed to live up to what it was supposed to do. So, Mr. Schwartz, could you talk, and you've done so well today, about some of the hardships that your member companies faced as a result of this eviction moratorium?
Sure. And one thing I would just point out, Texas is a model state for distributing.
I'm going to talk about that here shortly.
Okay, good. Yeah, the moratorium has created a lot of problems in our industry. One problem I would point out is it's a contributor to rent inflation. You know, someone suggested there could be 1 million units out in the country that are non-rent paying. That's been taken out of the supply when demand is surging. So Economics 101 says you're going to get big price increases, and that is an unintended consequence of the moratoriums. They have caused landlords to have an inability to pay all their bills or have to cut back on maintenance and keeping up their properties. It's been a very challenging environment when you have residents who haven't paid in 18 months. And there's some confusion with moratoriums. The residents, in some cases, think it's a rent holiday. And so they choose to spend their money elsewhere rather than pay their rent. And so this bill, we think is important if the effect of the bill is emergency rental assistance in the hands of people who have arrearages and want to stay in the community so they can continue to pay rent. But the moratoriums ultimately causes housing instability and creates massive debt on behalf of the residents and problems with the landlord.
Okay, thank you. I'm also concerned that all of the government interference into mom and pop landlords during the pandemic will lead to a greater consolidation within the industry. Most landlords I talk to are not massive corporations that do not have access to huge lines of credit when things get tough, but only have a few apartment units they have are able to maintain and rent out to the public. So when these people stop receiving rent payments and with the federal assistance stuck in bureaucratic limbo, many will not have any other option but to sell their properties. And Mr. Winn, how will the speed that these funds getting out the door help prevent industry consolidation and ensure that mom and pop landlords can once again thrive with their property?
I think it's a great point and a real concern, and nobody wants to see mom and pop landlords go under because of bureaucracy or because of process. So I really do think, as you said, the answer is in your question, which is the sooner we can get the money to those who need it, the better. And I think the bills that are being discussed do a good job of that. They do not do a perfect job of that. And one of the things that we need to figure out is to incent those small landlords to actually use this program, not to layer on restrictions that are burdensome to them, such as making sure that they would forgive rent or partially forgive rent that isn't covered by the rental assistance funding. I think that that would disincent small landlords, and that might have the effect that you're discussing.
Thank you. I've got limited time here. Mr. Schwartz, I'll keep this one simple. What is my great state of Texas doing right that other states around the country should mimic and copy?
And I have this information from my team on the ground in Texas. You're using a software called Neighborly Software, which is a best in class. And so I would advise the committee to follow some best in class best practices. It's a user-friendly platform. It can bulk load apps.
Or do you think would both renters and landlords in Iowa be better served by a group that is willing to really help them?
So I can't speak directly to the existence of a government that's not willing to help tenants and landlords who are struggling in this crisis. But I do think it's what Bear's saying is that all of these states have existing networks to help vulnerable households. And there is no reason why we should be reinventing the wheel and not using those networks. They are, as you mentioned, there are systems that are set up to help vulnerable populations access resources, and they should be the ones that state governments consult at the front line to set up programs. And states should not, or there should not be an opportunity for states to create additional barriers or different rules for programs that make it harder for renters and landlords to participate. If the federal law says something is allowable, it should be allowed. The legislation should probably say 3 months of forward rent should be paid, not can be paid. Just any additional flexibility to make renters and landlords access funds is welcomed.
Absolutely. I appreciate that. What's that?
I totally agree with what Kadeem just said. I think that was a great point that we've encountered as well.
Appreciate that. Well, then let me shift a little bit here to ERA2. Iowa's already said that they're not intending to apply for the funds, despite the fact that we continue to see renters evicted and landlords without unpaid rent. As of course I've mentioned, about 6% of the funding has gone out. So, both landlords and tenants lose when this rental assistance is not delivered. So, Mr. Schwartz, I'm wondering with the second round being available to help both renters and landlords for an additional 3 years, what's your thoughts on how this is going to affect landlords by turning this down?
Yeah, well, the reason landlords are turning that down is it doesn't prioritize arrearages. And we think that's an important fix in this bill, and the McHenry bill takes a look at that. And arrearages are so important because, one, the resident would like that arrearage cleaned up, even if they're not living there anymore. They still hold that debt, and the landlord's still pursuing collection. It could impact that resident's credit, and the landlord still has their bills to pay and needs that money to keep going. So we think that's really important, and we hope the committee can fix that. It's an important fix.
Thank you. My time's expired.
Thank you very much. The gentleman from Arkansas, Mr. Hill, is now recognized for 5 minutes.
Well, thank you, Madam Chair. I appreciate you and Patrick McHenry, even though you're not on the same page quite. This issue is important, and it's just drug on too long, which was why I was proud to support McHenry's bill to advance this funding, simplify it, and get it out, because that's the main issue here, is that we help the people who are in arrears on their rent. That's what Congress wanted to do last December. If you're in arrears due to losing your job or a terrible impact from COVID-19, that's what we're trying to do with these bills. All this other stuff, forward rent or whatever, is not the core mission. The core mission is to help those families starting last April who were brutalized in the economic collapse of shutting this economy down and haven't gotten back on their feet. And so it's frustrating not only to tenants and landlords, but it's frustrating to members of Congress that here we are in September, and we're still talking about how this could be a better program and help the people that we intended last December. I heard some discussion that was very interesting to me, and I'd like to try to get a little bit of data. I know it will be anecdotal. I know it'll be dealing with Mr. Schwartz and Mr. Winn's testimony, but you've raised something that in meeting with my mom and pop landlords here in Arkansas, I've certainly picked up on, which is someone is impacted by COVID-19 and is in arrears, April, May, June, July last year. They haven't gotten the benefit of this rental assistance, and they moved, they left. And so both of you referenced an interesting concept, which is of the rent in arrears that you talked about, Mr. Winn cited $37 million, how much of that is in a unit that's connected to a tenant who left months ago? Mr. Winn?
So a significant portion, I don't have the number in front of me exactly, but it is very significant. In fact, you can make a connection between the uncommunicative residents, the ones that we've not been able to reach, with the ones that are more likely to leave because they don't believe that the system will help them, or they don't believe that the program is for them, but they do know that their balances are accumulating. So I do think that there's that connection, and that there's significant nationwide back rent owed for vacated apartments for folks that don't believe they have a way out.
Yeah, and so that makes this even more complicated, I think. Mr. Schwartz, let me hear you on that issue, if I could, please.
Yeah, I don't have the exact number. Our total 30 days or greater past due is $8.5 million in our portfolio. I don't know what percent of that is a past due for someone who doesn't live there. I would say, I don't think it's significant. I think it's 10 to 20%, and that's a guess.
Okay. Yeah.
But it's a meaningful amount.
But I think it's a key point here about there is no tenant to fill out paperwork. The tenants walked the lease and left. And so that's a whole nother complex. And we're not per se suggesting they be gone after, but we suggest that we be able to process that money and get that vacant unit paid off and make that less of a problem here. So I hope that we'll put some priority on that as we talk through these issues. I thought that one was an important one to highlight today, Madam Chair. Also, Mr. Winn, you talked about that you described some of the speeding provisions like bulk applications and informed consent that are in Madam Chair's bill were helpful, but that they are not as helpful because then we extend this eviction moratorium. So you're arguing, Mr. Winn, and I'll get you to respond to Mr. Schwartz, that these are useful items to help speed up the McHenry effort of getting this money out, but it's a contradiction to extend that eviction moratorium. Is that your view, Mr. Winn?
I would say, yeah, I think there should be a middle ground. I believe, as you had mentioned, there are provisions in the bill that are both necessary and will be very effective. I do think they are burdened by more restrictions that will have the unintended consequences of having landlords not wish to participate.
All right, Mr. Schwartz, Mr. Schwartz, real quick response there.
Yeah, there are two things in the bill that could cause landlords not to participate. And one of them is a 120-day eviction moratorium if you accept the ERAP funds. And the second is the cancellation of debt if you accept ERAP funds, even if the ERAP funds don't pay all of the debt. We think that'll impact landlord participation.
I really appreciate those candid, short responses. Madam Chair, thanks, and I yield back to you.
Thank you very much. The gentlewoman from Massachusetts, Ms. Presley, is now recognized for 5 minutes.
Okay, thank you, Madam Chair. I know firsthand the fear and the trauma that comes with an eviction notice on your door. Evictions are disruptive and violent. These are violent events which destabilize families, but make it more expensive and challenging to rent safe housing in the future, to apply for credit, to borrow money, or to purchase a home. Currently, almost a third of Black renters are at risk of eviction. This eviction crisis is exacerbating economic injustice for Black families across America. Ms. Yentel, while there is a clear economic justice case to support eviction moratoriums, wasn't the legal justification of the CDC eviction moratorium always to help us get COVID-19 under control?
Yes, absolutely. The purpose of the CDC federal eviction moratorium was to slow the spread of COVID-19 and contain the virus. And research has since shown that expired eviction moratoriums led to as many as 400,000 cases of COVID-19 and as many as 11,000 deaths.
That's right. So when I say eviction is policy violence, that's not just some catchy turn of phrase. We know that when 27 states lifted their eviction moratoriums during the pandemic, again, it led to some 433,000 preventable cases of COVID-19 and 10,700 preventable COVID-19 deaths. This policy failure has ended the lives of more than 10,000 Americans. Now, earlier this summer, before its expiration, some Democrats, including our chairwoman, Maxine Waters, and myself, fought hard to implore every option to extend the eviction moratorium, including passing legislation. Now, while we were successful in securing a targeted CDC extension, while we were successful in securing a targeted CDC extension for a month, at the time, there were not enough members of Congress that were willing to vote yes to help pass this common sense legislation to prevent a public health crisis within a public health crisis. Somewhere along the line, the conversation about the eviction moratorium shifted from it being a reasonable public health measure into an argument that Congress was anti-small landlord. That's not it. This is about saving people's lives. That was a ploy to divide and pit working families against working families. Every proposal before Congress has provided relief for renters and small landlords alike. Then I discovered that the National Association of Realtors was the largest PAC donor to candidates in the last election cycle, and suddenly that shift made sense. The fight to extend the federal eviction moratorium has been derailed too many times because the single largest PAC donor is the organization who was fighting from Congress to the Supreme Court to ensure that renters are put last, which means they're putting the public health last. So let me be clear. Our advocacy is about saving lives. Congress has provided $46 billion to get landlords out of debt, and now we need to protect renters too. Renters may not have a multi-million-dollar PAC behind them, but they have a growing number of members of Congress in their corner. Ms. Yentel, yesterday, Dr. Fauci said that COVID-19 rates are 10 times too high to consider the spread under control. Do you think that the federal housing agencies are doing everything in their power to get COVID-19 under control by protecting renters from eviction?
I think they can and should do more. And Congress should as well. I mean, clearly Congress should implement a federal eviction moratorium as long as the Delta variant is surging and people are dying. But as you said, Congress doesn't have the votes to do so, and so federal agencies should act. We have urged the Department of HUD to implement an eviction moratorium for all federally subsidized properties, which we believe they have the legal authority to do now. And we've urged FHFA to consider what authorities it might have to similarly implement an eviction moratorium on federally backed properties. Those two actions could protect about 30% of renters nationally.
Thank you. And we know there's an estimated 750,000 renters that could be evicted in the next few months. This is an all hands on deck moment. This is a public health emergency. I urge every level of government to take urgent action to keep people safely housed. And I yield.
Thank you very much. The gentlelady yields. Mr. Kustoff is now recognized for 5 minutes.
Thank you, Madam Chair. Thank you for the witnesses for appearing. Thank you for calling the hearing today. And I think one thing we've heard is that we're all frustrated with the lack of funds that have been distributed by the federal government, and I think many of us have concerns that we've not heard from Secretary Yellen about the process, and that she should be here. But with that said, Mr. Winn, to you, can you talk about the practical effects, if you will, the problem getting in touch with past tenants who've already moved out and have outstanding payments? Practically, are you able to get their consent, and how would you go about doing that?
Yeah, so as I alluded to earlier, this has been a real challenge for us. And I made a point of describing all of our outreach efforts at both local levels, state levels, federal levels, working with churches, community organizations, and yet we still have been unable to reach about half of the tenant population, despite having filled out the applications, knocking on doors. There are many, and as I alluded to, there are many reasons that a tenant may not feel comfortable signing that document. And this is not meant to demonize any tenants. In fact, it's meant to recognize that that problem exists and make sure that landlords can apply with informed consent on behalf of those tenants. Else I just simply believe the money will not get out there. It will not get to those tenants. Those balances will chase those tenants to their next place they live on their credit report. It's bad for everybody. I don't think we could have done anything more than we've done, and I still think that we are only 50% successful. I worry about the smaller landlords without our resources. They would have been less successful.
I have answered this, but I'm going to ask you in a different way. Prior to the pandemic, prior to 18 months ago, and I frankly applaud everybody the way that you tried to work with people. because there was no playbook, there was no historical guide how to deal and how to navigate through this. But with your outstanding balances, with the tenants' outstanding balance before the pandemic, what would that balance be where essentially they were past the point of no return? In other words, they couldn't pay back a past balance and you have to work on evictions.
Sorry, you were breaking up a little. Could you say the last part of that question?
Sure. Prior to the pandemic, what level of back rent do you say is past the point of no return that the tenant would be unable to pay back and you would have to begin eviction proceedings?
Yeah, so I would say from a statistical point of view, generally speaking, we as a developer, as an owner, would underwrite 1% to 2% bad debt as an allowance. So when we look at the entire rent roll, you might have an allowance for 1 or 2%. That number has increased significantly because of COVID. And one of the things that I think everybody on this call is worried about is that it's mounting. It is not getting smaller. There continues to be folks who suffer job losses have largely not rebounded because the COVID epidemic is still with us.
Thank you, Mr. Winn. Mr. Schwartz, if I could, with you, and I think that Mr. Hill was asking you about the Expediting Assistance to Renters and Landlords Act, the 4-month eviction moratorium. Can you talk about, again, the practical effects and proposal in general, what's good, what's bad? Follow up on your testimony.
Yeah. So the best eviction mitigation tool is the ERAP funds getting in the hands of the landlords. If you tie that to a 120-day eviction moratorium, what is going to happen is the landlords have shouldered the burden of this pandemic over the past 18 months and have large rental balances due to them. And if now that is gone, at least the federal moratorium, and they're told you have to sign up for a new moratorium if you accept the emergency rental assistance, there's going to be a lot of reluctancy. And I think you're going to kind of do the opposite of what the bill is intending to do. You're going to contract the number of landlords who want to participate in the program by including that in the bill. And that's our concern.
Thank you, Mr. Schwartz. My time has expired. I yield back.
Mr. Lynch?
Thank you, Madam Chair. Can you hear me? Thank you very much. First of all, thank you, Madam Chair, and I appreciate all your efforts to get this money out. But we are facing some difficulty here, but I do support your solution. I actually know Mr. Winn personally. He's a friend of mine. He has been, his dad, I actually worked with his dad back in the day, developing a lot of the affordable housing in my district. And I want to just say a couple of things about the Winn companies before I ask my question. Number one, when this pandemic first hit, and there was great anxiety out there, as there is now, the Winn companies came out right away, and they did two things. Before Congress could act and before the CDC could act, the Winn companies came out and they announced to their tenants, well, first of all, they announced to all their workers. And so we, in our district, we have union carpenters, union electricians, union plumbers, union laborers that maintain the housing, and they do a great job. Well, the Winn companies came out right out of the box when COVID hit, and they were shutting down jobs all over the place and asking people to hunker down. The Winn companies announced publicly that they would not lay off any of their workers and that they would continue to pay them to, you know, do the plumbing jobs and and to maintain the property. So that lowered the anxiety level among a lot of the workers. The second thing they did, and again, this is before the CDC moratorium, they came out and announced to the tenants that they would not evict anybody for non-payment of rent. And they've got thousands of units. So look, and that did wonders for the phone calls that I was getting to my office regarding my folks in public housing. And I know most of the members on the committee realize I grew up in public housing, lived there for almost 20 years. Myself, my mom, my dad, my 5 sisters. The local housing project that we grew up in is now renamed after my mom, the Ann Lynch Homes at Old Colony. We're very proud of that. But so I'm all in on public housing. Look, if we didn't have public housing, my family and I, we would have been homeless. And I know what that fear feels like. You know, my dad used to say that, I mean, we had some tough times growing up. My dad used to say that we had to save up to be poor. We had real difficulty. And proud of my dad and my mom for pulling us out of that. They both worked really, really hard. And, you know, I realized the opportunity that public housing gave us. So Gilbert, I'm going to ask you, Mr. Winn, look, you and I know we've been trying to develop affordable housing in the city of Boston, which is a high rent location for years. And we got a couple that are coming up that we're having progress on, which is good, thanks to Ms. Waters. Now, what is the most significant obstacle for us? I mean, thanks to Chairwoman Waters, we're finally getting back into the business of affordable housing. We've been retrenching at the federal level for the past 20 years. And now Maxine, God bless her, has pushed a lot of initiatives to help people in public housing and to create more of it. But what is the biggest obstacle to us? I mean, even when we have land available, we're having difficulty developing affordable housing and workforce housing that would help the people that we work for. What are some of your thoughts on that?
Thank you, Congressman Lynch, and thank you for being those kind words, but being such a great advocate for the city of Boston and your district. Really, I think what Congress can do is to concentrate more resources to public housing. The low-income housing tax credit program has been wonderful for creating new low-income housing, but there is aged infrastructure in public housing across the country, and for years it has been underfunded. So I want to thank the committee. I want to thank Chairwoman Waters, and Congressman Lynch, and everybody else who fights for HUD resources, because every day people are living in substandard conditions, not because of management, but because of a lack of funding. And so I think if we can increase the Choice Neighborhoods funding, the Old Hope 6 funding, I think we're going to be better off as a community.
Thank you. And Gil, Mr. Winn, I just want to say that I know that you do a lot of work on military housing, Fort Hood, Camp Lejeune, a lot of our bases. So this probably not appropriate at this hearing, but I would love to sit down and talk to you about how we can do a better job housing our men and women in uniform and their families. Thank you. I yield back, Madam Chair.
Thank you. The gentleman's time has expired. The gentleman from Ohio, Mr. Gonzalez, is now recognized for 5 minutes.
Thank you, Madam Chair, for holding this hearing today. And I certainly want to thank the ranking member for all his work on this important topic. Mr. McHenry has been talking about the importance of getting this right for months now, and he should be commended for his advocacy on behalf of renters and landlords throughout the country. The fact of the matter is that this program has been poorly designed from the beginning, and we should take next week's scheduled markup and include Mr. McHenry's common sense legislation to streamline federal dollars. We've put in a lot of programs since the pandemic has started, and I'll contrast this one with the PPP program. When you have insatiable need and a well-designed program, the money flows, it gets out quickly, and it gets into the economy in the right way. That's what happened with the PPP. It wasn't perfect, but there was a big need, and the program was designed for speed, and it got out. When you have a poorly designed program or a lack of demand, you get this outcome, which in Ohio is 6.8% of our money has actually been distributed. I do believe there's demand, but it's blatantly obvious when you look at the numbers that this program is poorly designed. And I would at least suggest we think about educating people, as more than 50% of renters and 40% of landlords are unaware of the federal assistance. But today we are talking about the trouble that renters and landlords have had in accessing federal assistance. And this is all within the backdrop, of course, of the eviction moratorium, which was in place until just last week. Mr. Winn, I want to start with you. Just briefly, what has been the financial impact on landlords, and how have we seen landlords respond to the moratorium by putting in restrictions on new units as they come available that may be a barrier to lower income Americans?
So I think that the repercussions are significant. And although I think we're, as a community, an industry rather, very excited to see these changes to the ERAP program, because so many of the hardships that are currently outstanding among the landlords would be resolved through a better administration of these funds. So we are talking about the right thing. If the administration of these funds were not improved significantly, then the $37 million of owed rent in our case, the billions of dollars across the country, they're literally going to be lost, because again, tenants are going to move on, landlords are going to lose their properties to foreclosure, and they'll never recover. So the effect has been significant, but there is a wait and see attitude to see if we can figure out this ERAP program, because that'll make a huge difference.
Thank you. And again, Mr. Winn, in Chairwoman Waters' bill, it contains a provision which states that if a landlord receives rental assistance without the consent of the renter, even if this is payment only partially covering the renter's debts, that this payment will satisfy all monetary claims against the renter. Are you concerned that this provision specifically will deter landlords from seeking out emergency rental assistance should that provision be enacted?
Yeah, it's a subset of the provision. Yeah, is that requirement to write off partial balances if only partial funds are received? I do believe that's a disincentive, and I don't know that it's necessary. I believe a bill could create other incentives to stably house folks that don't, and to take these funds that don't require write-off of past due debts. There can be requirements to accept rental assistance program funds, as an example in the future. That might be a better way to incent landlords to do it than to say, if you accept our money, you are writing off a 30% loss. I am worried how that will affect the outroll.
Yeah, thank you. I share that. And before I yield back, it just seems like we have a poorly designed program. I think that's very obvious given the bottlenecks. Again, 6.8% of money distributed in my home state of Ohio. A very poorly designed program, and then we have a bad idea to fix a poorly designed program. So I oppose that bad idea. I support Mr. McHenry's legislation, and with that, I yield back.
Don't forget, we had to correct the problems with PPP also. The big banks created their own portals and took care of their concierge clients. We had to put more money in it to straighten it out. It was not a perfect program. We made it work, as we're going to make this.
What I said, I did say it wasn't perfect, but the money got out.
Ms. Dean is now recognized for 5 minutes.
Well, thank you, Madam Chair. Thank you for convening this important hearing and to be focused on solutions and success in making sure we protect people from evictions. And I say that with a special twist this week because in my area of Montgomery County, Pennsylvania, we were shockingly hit by Hurricane Ida, associated tornadoes, devastating losses to housing, to tenants and their tenancies, to landlords, to homeowners, to businesses, small, medium, and large. We had biblical level flooding in my district and tornadoes that we have never, ever, ever seen, losing a lot of our housing stock. So I offer that as a backdrop to say we have to find the solutions. I wanted to start with you, Mr. Morris, and I know you've been talked with a lot, but with good reason. I'm from suburban Philadelphia, so I have heard about your program and I'm thrilled with its level of success. It's always good to have a Philadelphia presence on our panels. I read your testimony and learned more of the details of the eviction diversion program and emergency rental assistance program in Philadelphia. I was hoping you could offer us a little bit more granular details as to the success. Specifically, how many tenants have participated, how many landlords have participated, what proportion of cases did mediation result in a good outcome or some agreement, and your high percentage of being able to deliver relief is just to be commended. So can you offer us a little more specifics on that we might learn?
Sure, I can try my best to offer you specifics with the data that we have. I can tell you so far across all phases, we've spent $165 million in rental assistance dollars that have gotten out of the door. In phase 4 alone, there have been about 13,454 households that have been assisted so far. There are about, I think, 50,000 applications that are still pending, both as a resource limit and also as just the time to process the applications are not there, and we're working as hard as we can. We've spent 86% of the money that has been allocated to us across all phases of the emergency rental assistance program. So we are spending the money, and in terms of the average amount of assistance that's being paid out, we're paying out 8 months on average to households. And utility assistance, we're paying about 4 months on average to a household that applies. I don't specifically have the number of landlords and tenants that have applied separately because we track them as households. The way our system is designed, there's a portal by which a landlord can go in and pre-register, and some have been registered since April when the phase 4 was first actually opened in Philadelphia, and then a tenant can apply with their applications, and those applications are synced on the back end and processed as one. So for every household, I would not consider that a landlord in and of itself, because landlords do own several properties, but we measure them by households that have applied, and there are about 50,000, as I said, that are still outstanding, that we just don't right now have the financial resources to help all 50,000 of those, because we spent 86% of our funding thus far. But in terms of demographic data, I can provide that over 74% of the households that we have helped have been below 30% of the area median income. So those are very poor households that would otherwise not have any funds left over to help them reach any sort of crisis, never mind an ongoing COVID pandemic. They wouldn't have $500 to pay on a bill that they're not expected. So we are helping the most vulnerable, and our clients are also predominantly female. Over 66% of the applicants have been female.
I wanted to ask you very quickly, if you could, how did you spread the word? And then I want to get one more question in if I have the chance.
Sure,
we
had an existing network of housing counselors from the 2008 housing crisis. The city has also done a lot of advocacy around the program, and we have tenant advocates that have been on the ground working. And as someone contacts us about an eviction or housing instability, we provide information that rental assistance is available, and the courts has also cooperated with us in that process.
Thank you for that extraordinary success, and I hope we send you the resources you need. Mr. Schwartz, I've got just a little bit of time left, but from the landlord perspective, because our committee and our Congress was always concerned with tenants and landlords, what have been the successful outreach that you've participated in?
The outreach as far as promoting the programs, the ERAP program?
Exactly.
Yeah. Well, in our communities, we make all our residents aware of rental assistance. Even before the pandemic, if anyone had trouble paying rent, we connected them with local charities or other programs. So nothing has changed. With the ERAP program, as I mentioned earlier, this has been an all-hands effort to help our residents.
I'm so sorry. We have to move on. The gentleman from Wisconsin, Mr. Stile, is recognized for 5 minutes.
Thank you very much, Madam Chairwoman. I'd like to dive in and follow up right where my colleague, Mr. Gonzalez from Ohio, left off. In particular, if I can, to you, Mr. Schwartz, ask you about the impact of landlords being forced to take a haircut. Maybe on the surface, it sounds like that might be a productive thing. It's going to help renters, but I think not in a static model, but in a dynamic model, where are those costs going to go? And so I'd love your insight, in particular, if you think that there's going to be landlords across the country, they're going to take those losses in one place and then reach out to other renters in their pool and try to recoup those costs, and what the impact would be on other renters that were not the beneficiary, where the landlord took a haircut. Could you just start there, and then I have a follow-up question to that, if you would, Mr. Schwartz?
Yeah. Well, one thing I mentioned is we have rental inflation going on now that we probably all have read about. And one of the contributors are kind of the costs associated to the industry with moratoriums and haircuts, as you suggest. In California, when ERAP first came out, there was a blanket 20% haircut to the landlords by the state. And that, thankfully, that was changed because the flow of funds from ERAP was going very slowly because of that haircut.
So you're seeing the causation of some of these increases being, well, you take a haircut on the left, but ultimately you're raising prices on the right. Does that uniquely impact low or moderate income renters?
I believe it does. Low and moderate income renters have a higher percentage of their income goes to rent.
Okay.
And
I trying to move quick. I appreciate your insight on that. Let me shift over to you, Mr. Winn, if I can. One of the things I hear a lot from in Southeast Wisconsin, we have a lot of real small landlords. Once I lived in a duplex before I bought the house that I'm in today. I was a renter there. Often in the case here in Southeast Wisconsin, you'll have somebody who owns a duplex. They live in one side of the duplex. They have a tenant in the other. That's how they're covering their mortgage. Could you provide some insight as to how these policies have different impacts between the real big landlords that are out there versus these true mom and pops? I can't tell you how many landlords in a technical sense, but often they think of themselves as just a homeowner. They own a duplex or trying to rent out the other side, who've been negatively impacted either by the eviction moratorium or the ability to obtain funds, and what the impact, in particular on some of these smaller just families that are just trying to build some equity for themselves of this policy would be. Mr. Winn?
Yeah, so in Congressman Lynch's district, we call them triple deckers. So yes, I understand what you're saying. No, the impact has to be severe. I think at this moment, we know the statistics are, 10 to 20% of the funds have reached their intended recipients. So a small landlord that has 4 or 5 units or 1 or 2, that's the real estate tax bill. That's the mortgage payment. That's it. So we know that they don't have any wiggle room. They don't have any ability to go get a line of credit or to cover these gaps. So the urgency is just as important as the actual amount of money for those small landlords. So I think the committee's doing the right thing. We're here talking about it. We're here saying how we can get the money out. But I can only imagine the hardship small landlords are going through.
I can't tell you how many of them called my office frustrated with the policies put in place by Washington, frustrated with how poorly run and operated this has been in getting the funds out. There's a lot of people who are looking at their home's mortgage. If you own a duplex, your home is on the line when the other half of that duplex is truly paying zero rent and you have no ability for recourse. It's a real serious problem, and appreciate you providing those insights, Mr. Winn. With that, Madam Chairwoman, I will yield back.
Thank you very much. The gentlewoman from North Carolina, Ms. Adams, is now recognized for 5 minutes.
Thank you, Madam Chair, and I appreciate the opportunity to share with you today, Mr. Yentel, Mr. Schwartz. Thank you both for being here. During today's hearing, we've heard plenty about provisions in our legislation that allows landlords to directly apply for back rent. Specifically, we've heard about landlords' hesitancy regarding the requirement that accepting ERA funds would mandate them to house a tenant for an additional 120 days. I think it's absolutely critical, though, that we tackle that hesitancy. And I want to talk just a moment about a solution that my local nonprofit is employing with a great deal of success. I represent North Carolina Ramp Charlotte, or Ramp CLT as we call it, is beyond any doubt one of the most effective ERA administrators in the nation, serving the entirety of the city of Charlotte and Mecklenburg County in North Carolina. They've been accepting self-attestations since the early days of the pandemic, and they've worked closely with our county, our city, and other nonprofits to distribute ERA funds rapidly and accurately and critically. In addition to any arrears they award, they also provide an additional 3 months of funding to ensure that tenants will remain stably housed. Now, those additional funds immediately help landlords and tenants come to the table and have made Ramp CLT one of the most effective distributors of ERA dollars in my state. So Mr. Yentel first, and then Mrs. Yentel, excuse me, and then Mr. Schwartz, as a way to help bring reluctant stakeholders to the table. Do you believe that ERA administrators should consider automatically providing several future months of rent along with any arrears?
Yes, thank you for the question. First, I think it's important just to clarify, as you did, that the prohibition on evictions for a short period of time is only for landlords who receive funds without any tenant involvement. That's a very important protection against fraud, against potential tenant harassment, against housing stability of tenants. I agree that the program that you named is a very strong program and has been from the very beginning. They were very early to get started in funding their ERA program. They set up a program that was very accessible for low-income tenants and for landlords, and they've been doing a great job in getting the money out. I think the solution that they came up with is a good, creative one that can be helpful in many cases. Certainly, it provides additional housing stability for those low-income renters, and it provides assurances for the landlords that those months of rent will be paid. So I think it's a good solution that should be considered. The only caution I would make is that in some communities, they would need to first be sure that they have enough ERA to cover the arrears of all the tenants in need before making this a future 3-month rent payment automatic for all applicants. But I certainly think that in some cases, and in cases where the tenant needs that additional assistance, I think that's a very good component to a successful program.
Thank you. Schwartz?
Yeah, I agree with Diane. I think you need to make sure you have enough money to pay the arrearages and what has been owed before committing to go forward. I think it would work on a voluntary basis. I think legislating it would, again, create this effect of reducing participation in the program that we don't want to happen. But I do think landlords would take advantage of it on a voluntary basis.
Right. Okay, Ms. Salazar, I want to just speak just a moment about the impact on women of color that COVID-19 has had. My conversations with Ramp CLT, our administrator, I was disturbed to hear that the highest number of ERA applications were coming from African-American women between the ages of 20 and 35 who had at least one child. So how can Congress ensure that the outcomes of the Emergency Rental Assistance Program do not exacerbate existing racial inequities in housing?
Thank you so much, Ms. Adams. It's such a critical issue. We knew from the start that this pandemic would have a disproportionate impact on BIPOC communities, communities of color, and we're seeing that play out, of course. In our program here in the state of Oregon, we have contracted with local community-based organizations to do outreach in specifically communities of color with translated materials, to get the trusted relationship with community-based organizations to help folks apply for rental assistance. So that outreach is critical. And the other piece that we are employing in our state is priority within the queue. So I would say that there are some reforms in the proposed legislation that we're talking about today to increase that technical assistance and community engagement.
Okay, thank you.
The gentlewoman's time has expired. Thank you. The gentleman from Texas, Mr. Taylor, is now recognized for 5 minutes.
Thank you, Madam Chair. Appreciate this hearing. I will comment that it's clear to me from all of our colleagues the importance of trying to get this program to work properly and the frustration with it. And I certainly appreciate that bipartisan consensus that this needs to work well. What I have to admit I'm frustrated with is that, where's the administration? They've been trying to, operate this program for months and months and months, and they're not here. They're not providing the suggestions. I mean, I know, Madam Chair, you're very passionate about protecting renters, advocating for essentially the eviction moratorium. The president only at the very last minute advocated for it, and then ultimately tried to do it by rule. And we knew that was unconstitutional, knew that it was illegal, it was struck down in court. He could have been here, here meaning in this building in Congress, advocating for change months and months ago, but he hasn't. And so here you are, Madam Chair, working to try to address this and quote unquote clean up the mess. So I wanted to just say one thing that is concerning to me in this legislation is the idea of self-attestation. I know that nobody here wants to see limited government resources, limited taxpayer resources wasted, squandered, used in a way that is fraudulent. And I think I speak for all of us. None of us want to see that. I am concerned that self-attestation opens the door for fraud. And so I really hope that we would revisit that. I know we want to go expeditiously, and I certainly concur with that general sentiment of let's move quickly, let's make sure we get these dollars out. And I think that you've heard Republicans and Democrats talk about the slowness of the process. And so in terms of getting the dollars out, and that's what we're here. We're here to talk about why it's slow, how can we improve it. I think it's a little late to be having this discussion. We should have been having this discussion months and months ago, but nevertheless, here we are today. Ms. Salazar, question for you. You indicated earlier, a few hours ago, I think that you had participated or been consulted with the drafting of the legislation in front of us today. Did I hear you correctly?
Thank you so much, sir. Yes, the National Council of State Housing Agencies has been engaged in these dialogues around the legislation.
And was that consultation by the legislative branch or the executive branch?
It was the legislative branch.
Okay, so have they been reached out to by, the Department of Housing and Urban Development or the Secretary of Treasury? Has there been any effort by the executive branch to try to reach out to you to ask about the implementation of this program?
Certainly, Representative. We have had dialogues with officials at U.S. Treasury. They have been helpful dialogues. NCSHA proposed, for example, the bulk payment process to get bulk payments out to landlords. The administration was receptive. I think where we stand at this point is that the guidance from Treasury has been helpful, but we need those statutory changes to really codify the reforms necessary to be able to expedite the program. So really building on some of the early dialogues we've had with U.S. Treasury. I will just say one other piece is that we are in dire need of guidance from U.S. Treasury around how they will approach the reallocation issue. We are rapidly coming up on September 30th. Programs like ours in Oregon, we're pulling out all the stops to expedite payments getting out the door. And we need to understand clearly from U.S. Treasury that they will take into account things like the strong demand for the program on the ground and the efforts that states like ours are making to expedite payments. So that is one area where we have not received the guidance that we need.
So, are you testifying here today that you're still waiting for guidance from the administration in order to implement these programs?
I would say in some regard, the guidance has been forthcoming. For example, the recent guidance.
But I think you just said we're waiting for guidance, and I'm just, is that right? You were waiting for guidance, is that correct?
We are waiting for guidance, sir, specifically on the issue of how Treasury will address the September 30th spend.
And again, I'll just express frustration, individually, and I think I speak for my colleagues. I'm really frustrated the administration isn't really coming to the table, isn't really offering legislative solutions, isn't really leading on this. I'm glad to see the chairwoman and the ranking member working, in slightly different context, but trying to come up with solutions. And I really think that the executive branch needs to be part of this and part of these discussions. Madam Chair, I yield back.
Thank you very much, and we're all working toward finalizing on some of these issues and concerns. I'm working with the Treasury, working with the administration, and offering to work with the ranking member. So thank you very much. Next, we will hear from the gentlewoman from New York, Ms. Ocasio-Cortez. You are now recognized for 5 minutes.
Thank you so much, Madam Chair, for hosting this hearing. And as Representative Dean had mentioned earlier, we had just experienced devastating floods for which my district was ground zero in New York City on the floods from Hurricane Ida. And this has been a travesty in my district. We have lost 12 people in these floods. And the connection here is that in almost every person lost to the floods, it was related to our housing crisis. The lack of available housing stock and the fear of eviction has existed even prior to the pandemic, and the pandemic has only made it worse to the point that people are seeking alternatives to the housing stock that are often dangerous. Now, that being said, speaking about those longstanding inequities, many low-income renters struggle to make ends meet even before the pandemic. And with the lapsing of unemployment, the striking of the eviction moratorium, all of these things have placed renters in an even more perilous position. We've discussed about some of the difficulties, and the committee has addressed some of the difficulties in state implementation, but I also want to talk a little bit about the difficulties in getting these funds out with a small segment, rather the segment of landlords who are refusing to participate in emergency rental assistance. Now, Ms. Yentel, is there evidence that lack of tenant participation is a widespread problem for the emergency rental assistance program?
I have not seen any evidence or data to show that there's a widespread problem of tenants not participating. There is clear evidence of tenants not completing applications, which points to inaccessible and overly complicated applications that need to be simplified.
Okay, I see. And would you say that in relation to tenant participation, is lack of landlord participation in the program more of a frequent problem that we're noticing?
We have seen evidence of this, yes. In a survey that we and others did, about 44% of program administrators said that landlords refusing to participate in ERA programs was a challenge. And from some of the more recent conversations, I would say that that number has likely grown.
So that means that when landlords refuse to participate, some emergency rental assistance programs are not required to provide assistance directly to tenants, and they could face eviction or homelessness if their landlord vetoes the application. Is that right?
That is right. Unfortunately, it's optional for program administrators to utilize direct-to-tenant assistance if landlords participate. And we're seeing that only about 28% of all ERA programs are explicitly allowing direct-to-tenant assistance. That means there are many tenants who are having their application closed, are not getting any of the assistance they need because the landlord has refused to participate.
And this is consistent with something I've been seeing, folks. So if you are a tenant and you want to make right on your back rent, and you apply for the emergency rental assistance program, if your landlord has been trying to get you out, they can refuse in the majority of programs to accept your rental assistance and evict you and use that as grounds to evict you. Is that correct?
That is correct. And we're seeing some very egregious cases of tenants showing up in eviction court, say with the emergency rental assistance in their hands, and the landlord saying, I don't want it, and the judge allowing the eviction to move forward.
So it seems as though we have a very urgent issue, and I very much am so thankful to see Chair Waters address these issues. Now, my last question is, what types of enforcement mechanisms should we be exploring to ensure that the tenant protections in this bill are adhered to by landlords?
It's a really important point, and we strongly recommend that the legislation be very clear in identifying a federal agency, the DOJ or the CFPB, and giving them clear authority and responsibility to ensure that the tenant protections in this legislation are followed and adhered to.
Thank you so very much.
Thank you.
I would like to just chime in on this topic because I'm a landlord, so and I can give you some reasons we've seen landlords not want to participate. And one of in a state like New York, there are conditions imposed by participating, like rent freezes, not able to charge late fees, and extended, protracted moratoriums. So it makes it hard for the landlords to participate with all those conditions.
Thank you. The gentle lady's time has expired. The gentleman from Georgia, Mr. Laudermilk, is now recognized for 5 minutes.
Well, thank you, Madam Chair. First, I'd like to recall how we arrived at this point. First, the CDC established an eviction moratorium despite having no statutory authority to do so. Then, after Congress established a bipartisan rental assistance program in December, Democrats created an entirely new partisan program with a conflicting set of rules. Because of that incompetent lawmaking or policy making, the funds are now stuck in an administrative mess, and only a small fraction, has been distributed. When HUD Secretary Marcia Fudge testified to this committee 2 months ago, she said if we get the rental assistance programs to actually work, then there's no need for an eviction moratorium. But instead of focusing on getting the rental assistance program to work, Democrats tried to pass legislation to extend the eviction moratorium. When that failed, the president then directed the CDC to extend the eviction moratorium, which he knew was unconstitutional, and the Supreme Court struck it down. The HUD secretary also said streamlining the rental assistance program would help get the funds out more quickly. And unlike the members of the majority who are just now turning their attention to this, Republicans proposed a bill to fix the rental assistance program 3 months ago. There are more than 10 million jobs available right now, more than any other time in the history of this country. There are more open jobs than there are unemployed people, but instead of focusing on getting people back into the workforce, the majority now wants to remove any requirement for renters to have a hardship to receive rental assistance and make taxpayer-funded rent a long-term entitlement, regardless of whether people actually need it. Mr. Winn, one of the items in the majority's bill is that it would require landlords who apply for rental assistance on tenants' behalf to accept any amount they receive as satisfying the entire rent debt, even if the amount they receive is thousands of dollars short of what is owed. Does that provide any incentive to the landlords to apply for these funds?
Thank you for the question. And I'd answer that in 2 ways. One is, I think we would appreciate more clarity on what the proposal actually says, because read in its worst way, that could be true, right? Where by accepting $3,000 of rental assistance, you could be foregoing $6,000, and that doesn't help anybody. So I think it would be very important to clarify what those rules are, and just frankly, don't make them so burdensome that landlords can't participate.
I appreciate that. Also, the government is the reason why so many property owners have been unable to collect rent and evict non-paying tenants. Should the government make landlords whole by allowing the rental assistance funds to reimburse property owners even if the renter has moved? That's Mr. Winn.
Yes. I think that, and I mentioned this earlier, that is a critical aspect of this. And that's only going to happen more as we go through the pandemic. There are going to be tenants who see insurmountable balances of rent delinquency and just say, I got to move. And so it's almost an effective eviction, but it's somebody deciding to move. And unless the program explicitly allows rent on those vacant units, the landlords are the only ones left holding the bag. So the proposal really should, and I hope does, address that.
All right, thank you. Mr. Schwartz, do you agree that consolidating the 2 emergency rental assistance programs under the ERA 1 program rules would get the funds out more quickly?
I agree with respect to focusing on arrearages. Arrearages with respect to vacant units like you just spoke about, and occupied units. And by consolidating them, because of ERAP 1 did prioritize arrearages, we think that's very important.
All right. Well, Madam Chair, I have no other questions, and so I'll yield my time. Thank you.
Thank you very much. The gentleman from Illinois, Mr. Garcia, is now recognized for 5 minutes.
Thank you, Madam Chair, and thank you for your leadership on this issue. Good afternoon to all of our panelists. The majority of the constituents I represent are renters, so this issue is very personal to me. Millions of people across the country lost their homes after the last financial crisis 10 years ago, but working class communities like mine never recovered. Families got evicted and priced out. In Chicago, this is a racial justice issue. The Logan Square neighborhood alone in my district lost over 10,000 Black families and 20,000 Latino families in the last decade. I can't stand by and let this happen again. And that's why I fought for an eviction moratorium and why I fought for emergency rental assistance. And now I'm fighting to make sure that the program works for neighborhoods like those in my district. The whole point of rental assistance is to keep people in their homes, and it's our job to make sure that that happens. So I want to thank the chair and the ranking member for convening this important hearing, and thanks to all of our witnesses today. But I do want to direct my couple of questions to Ms. Yentel. You talked about the importance of tenant protections in the rental assistance program. I know firsthand how landlords have a lot of different tools to get rid of tenants they don't want. Filing an eviction in court is only one of them. Can you briefly talk about how landlords might get rid of tenants without formally evicting them? And is this common?
Yes, and it's important to recognize too that there are multiple reasons why landlords might refuse to be participating in programs, and we heard that concessions required of them is one. Another reason why we're seeing some landlords not wanting to participate is because they are in hot rental markets, and there's a financial benefit to actually evicting the current tenant, increasing rents, and making more money in the long run. There's also a challenge of landlords who have unlicensed or otherwise illegal units who can't access the emergency rental assistance funds. So we do see during the pandemic and at other times as well, unfortunately, ways that landlords harass or push out tenants. So it's not a formal eviction filing, and it's illegal in most places, but they might put a lock on the door and just not let the tenant back in. They might turn off utilities, turn off water, and force that tenant out. Or in less explicit ways, they use harassment to push that tenant out. It's part of the reason why it's so essential that these protections be included if ERA is given directly to landlords without any tenant involvement. It's certainly not all landlords who will act this way, but we have to prevent creating perverse incentives for landlords to potentially harass tenants, to push them out, receive the emergency rental assistance without having to agree to any of these other requirements that we're hearing are considered so onerous for landlords.
Well, thank you for that. And I have a follow-up question. How can Congress improve the rental assistance program to prevent landlords from unreasonably getting rid of tenants and claiming funds anyway?
Well, again, in most cases, landlords and tenants are applying for assistance together, and the landlord gets paid for the arrears that are owed to them. In those cases, there are ways the programs need to be improved, they need to be simplified, there needs to be self-attestation used, we need to do outreach to get that money out faster. In cases where the committee considers allowing for landlords to receive assistance without involvement of the tenant, there have to be strong protections in place for that tenant to remain stably housed. And so many of those protections are included in the chairwoman's legislation: protections against eviction immediately after receiving the funds, protections against going back and claiming more funds from the tenant in the future. Really important protections to ensure that we're not increasing tenant harassment or housing instability.
Great. Thank you very much. Madam Chair, I yield back.
Gentleman from- The gentleman from South Carolina, Mr. Timmons, is now recognized for 5 minutes.
Thank you, Madam Chair. We all voted for the CARES Act back in March of 2020. That legislation, of course, included an eviction moratorium, which would last until July 24th of 2020. I think that most people thought that was reasonable. It was the right thing to do. We needed to help people that needed help. But I don't think anyone on this committee would have anticipated or supported such a moratorium going on for another year. But that is exactly what happened. And even that wasn't long enough for some people. I also think it's fair to say that at that time, most of us serving on this committee truly believed that renters who were economically disadvantaged because of economic lockdowns, often imposed by state and local governments, should not have been evicted from their homes. That's just straightforward common sense. But so much has changed between then and now. Primarily the development and distribution of safe and effective COVID vaccines for anyone who wants one. This allowed the economy to largely reopen over the spring and summer months of 2021, making jobs available literally almost everywhere. There are 10.9 million jobs available in this country today. I talk to employers of all different sizes and industries, and a common refrain is always, we need more people. We need more people working. So jobs are available, and thanks to the vaccine, it is safe to return to the workplace. On top of this, as we all know, Congress has shelled out close to $50 billion in rental assistance funds to help renters cover back rent they may owe. These two developments, vaccines allowing for the economy to reopen, and the emergency rental assistance program made an eviction moratorium completely unnecessary many months ago. In the last few months, if it's taught us anything, it is that the current administration is completely incapable of putting a plan in place and executing it, with the primary examples being the disastrous Afghanistan debacle and this emergency rental program. We've also learned that President Biden has zero qualms about abusing his power. I think at the other end of Pennsylvania Avenue, we've forgotten that in our systems of government, Congress writes the law and the president executes them. He doesn't get to just do whatever he wants or get pressured into doing when people camp out on the Capitol steps. The Supreme Court has already knocked down this illegal moratorium extension and will surely do the same for the vaccine mandates we saw last night. What is sad is that this was all avoidable. A competent White House would have had ERAP up and running and working with state and local governments to distribute dollars in a productive way that would have made the eviction moratorium debate a moot debate. I know everyone on this committee wants to help people in this country that need help, but we need to be thoughtful in the manner in which we deliver that help and make sure that it's not counterproductive. One of the biggest problems we've had implementing any new program, particularly ones that are quickly stood up and quickly send money out the door, is with making sure that only the intended eligible recipients get funds and fraudsters get locked out. I think that we need to really be careful that we're not going to do more harm than good. We have to get back to work. We have almost 11 million jobs available, and the only way that we're going to get out of this, the only way we're going to get our economy back on track is by getting back to work. Mr. Winn, I know hindsight's 2020, and it's easy to be a Monday morning quarterback, but looking back over the last 18 months, if you knew all this was coming, what was the one step you wish we could have taken to weather the storm is COVID, and why?
I would say I feel like I'm repeating myself, so I apologize, but I do believe it would be the informed consent model for tenants rather than the wet signature. I do believe that would have doubled the amount of resources we could have given to tenants on that basis.
Thank you. I just want to remind everybody that we have $30 trillion in debt, and we're talking about spending trillions and trillions of dollars we don't have. Our kids, our grandkids, our great-grandkids are going to have to pay this money back. It's not just funny money. We gotta get serious, and we gotta help people that need help, but we gotta get our economy back open and get people back to work, because that is the only way that we're going to be able to help the people that need help the most. And with that, Madam Chair, I yield back. Thank you.
Thank you very much. The gentlewoman from Texas, Ms. Garcia, is now recognized for 5 minutes.
Thank you, Madam Chair, and thank you once again for your leadership on this issue and prioritizing this very important piece of legislation that will help many constituents in my district and all across America stay housed this winter. During the pandemic, our county has faced unimaginable challenges. In Houston, many families were still trying to recover from Hurricane Harvey when COVID hit. As of now, hundreds and thousands of Houstonians are behind on their rent. And since April 2020, Harris County landlords have filed almost 34,000 cases for eviction. 34,000 just here in Harris County. With our dollars that we have received through the ERA1, as the on page 10 of Ms. Yellen's paper suggests, Harris County is at 81.9%, almost 90% of the dollars. I understand anecdotally that the dollars are gone, and I can tell you that if there's any city or state or county that has extra dollars, we will take them because the need is great in Houston and Harris County. We must also make sure that all the measures that we're taking here do not adversely impact on any renter's ability to apply for any of these funds. So my first question is for Ms. Yentel. Ms. Yentel, in your testimony, you highlighted that among those behind on their rent, 31% of the households were forced to use debt instruments such as credit cards to make ends meet. And last month, the New York Fed reported that household debt is at a historic high of almost 15 trillion, that's trillion with a T, marking the largest nominal household debt increase since 2007. This, of course, concerns me because some people did pay for their rent. They just put it on their credit card, and now they're stuck with credit card debt. So what can we do to make sure that we aren't forcing people to take on more risk than they're ready for? And could you elaborate on any of the ripple effects of any of these financial hardships due to housing, what that does to consumers and the economy in general?
Yes, and it's one of, I would say, the very unfortunate consequences of Congress having delayed action on finalizing emergency rental assistance for so long. As you know, in the House of Representatives, emergency rental assistance was passed 3 times in May, June, and July. If the emergency rental assistance had been enacted at that time, it could have been used as it was designed, which was to keep low-income renters current on their rent, to help them pay the rent during the pandemic and not fall behind. The legislation was held up in the Senate under Republican leadership, and it wasn't enacted until December of 2020. By then, tenants had accrued an estimated $50 billion in rent arrears, and it became a different need that the program was trying to serve, which was to help pay those rent arrears. So that's one of the more unfortunate outcomes of how long it took for Congress ultimately to enact this. As you said, in the meantime, there were many tenants. Most tenants did everything they could to stay current on their rent during the pandemic. And some of them had to make trade-offs in not buying store-bought food or paying for internet despite their children needing it for virtual school. And many of them took out loans or used credit cards to pay for the rent. We saw that the data is very clear that there was an increase in the number of tenants using credit cards to pay the rent. And in fact, many landlords were in communications with tenants encouraging that to keep the rent payments current. It is unfortunate now that many of those tenants hold that debt but are not able to be paid back through the emergency rental assistance program for the debt that they owe. And I would encourage the committee to consider ways to make tenants that can prove that they used credit cards or otherwise took out loans to stay current on their rent, that they could access emergency rental assistance to make them whole as well.
Thank you. And quickly, Mr. Morris, I had a question for you about translation services and interpreters. I think it was you who testified that some of the delay and some of the concerns on the renter side is not having the forms and the information, the outreach information in the language of their own. Is this a problem nationwide that we also need to address?
I believe this is a nationwide problem, and all of our applications in Philadelphia are available in several languages based on demographics for the populations.
But should this be a mandate in the bill itself? Because obviously
It should.
We're hearing that in some cities and some programs, that is not the case. So the only way that we can make it uniform and that we make the programs accessible to everyone would be to put it in the bill. Would you agree?
I agree. Even if the bill itself is not changed, there should be a person who can interpret on behalf of someone in a different language available.
Ladies,
Thank
time
you.
has
Thank you,
expired.
and I yield back. Thank you,
Thank
Chairman.
you. The gentlewoman from Georgia, Ms. Williams, is now recognized for 5 minutes.
Thank you, Madam Chair, and thank you for holding this hearing today. Too many renters, through no fault of their own, have fallen behind on rent payments during this pandemic due to economic hardship, forcing people on the streets during a pandemic that is still raging, y'all. And I've seen it firsthand. Back in early June, when a local eviction moratorium expired, I posted pictures on social media for my district where people's belongings have been tossed out on the street. And this was with the CDC eviction moratorium still in effect. That's because people didn't know how to access the actual moratorium, let alone the rental assistance associated. Those pictures were a stark reminder that we must keep working to find a federal solution to keep people in their homes. I knew that we had to pull every lever to protect tenants from eviction and give them a leg up in recovering from this pandemic. For one, the CDC eviction moratorium protected countless families, which is why I was quick to co-sponsor Chairwoman Waters' bill to extend it through the end of the year. Unfortunately, some members of Congress stood in the way of this extension despite the tireless work of Chairwoman Waters, Speaker Pelosi, and so many other members of Congress working to protect our constituents. However, like Chairwoman Waters, I knew that we couldn't stop fighting. We still have to address the fundamental problem of getting folks out of rental debt. The key is efficiently distributing the rental assistance already provided by Congress, which has gone out too slowly in many localities. This week, I was proud to join Chairwoman Waters in co-leading the introduction of the Expediting Assistance to Renters and Landlords Act, which will make the rental assistance Congress approved go out more efficiently. And today, I'm glad to talk more about how we get rental assistance to the people. Ms. Yentel, in your testimony, you noted that my home county of Fulton County, Georgia, has distributed 76% of the ERA 1 funds that was allotted. However, the rate is not that high in every county nearby. In fact, you noted that Georgia as a whole has only distributed 3.6% of its funds. If enacted, to what extent will the Expediting Assistance to Renters and Landlords Act help to reduce distribution disparities in places like my home state of Georgia? And in addition to pushing for passage of this legislation, what should members of Congress be doing to help more localities get assistance out the door more quickly to people in need?
Thank you. The legislation that Chairwoman Waters has introduced and that you co-sponsored would speed up the assistance of emergency rental assistance in several ways. And it would build on lessons learned and best practices during the pandemic. So we have learned by now very clearly what makes some programs so successful and what makes some programs much less so. And so some of the reforms that are included in this legislation, for example, would require that all programs use self-attestation for all eligibility requirements. This would drastically streamline applications, speed up the delivery of funds. It would also require that all programs utilize direct-to-tenant assistance when landlords refuse to participate, ensuring that tenants aren't penalized for their landlord's lack of action. It would redefine eligible grantees for emergency rental assistance to go beyond state and local government entities to include the community-based nonprofit organizations that are doing the door knocking and outreach to get tenants engaged in the process altogether. It would prohibit the requirement of written leases, which has also been a barrier for some landlords and for many of the most marginalized tenants who have informal leases but still owe rent to their landlords. So there are a number of really important changes and protections in the legislation that we support. In terms of what more members of Congress can do, I think this legislation is a very good start, but I also think taking the actions that you've taken in your community to help improve and encourage improvement of these emergency rental assistance programs, the example that Chairwoman Waters gave of the actions she's taken in LA to connect legal aid attorneys with the emergency rental assistance with the landlords, This is really important leadership that all members of Congress could take, that could help educate constituents about the availability of resources and then help them to access them.
Thank you, Ms. Yentel. And not knowing what the future holds, do you think it would be useful to study the implementation of the Emergency Rental Assistance Program, including any changes to the program, to see how we might improve other programs going forward across the country?
Absolutely. We should be constantly studying, learning, and improving as we go for this and for any future programs that are similar.
Thank you, Madam Chair. My time has expired and I yield back.
Thank you. The gentleman from West Virginia, Mr. Mooney, is now recognized for 5 minutes.
Thank you, Madam Chairwoman. So we understand last month the White House essentially caved to political pressure from the left and unilaterally extended the eviction moratorium, even though they knew it was unconstitutional. President Biden, unconstitutional for President Biden to assume this power to himself, the power that is rightly placed in the legislature, the Congress. After the court struck down the moratorium and once again told the White House it was unconstitutional, Democrats in committee here in Congress finally decided to propose changes to the Emergency Rental Assistance Program. The Republicans already proposed changes to the Emergency Rental Assistance Program months ago, well before the eviction moratorium standoff took place. Instead of going to the president to abuse his powers and working with committee members on common sense we should have worked with committee members on common sense reforms. Now the Democrats are rushing to the rental assistance program through this process. We're scheduled to mark up this bill on Monday of next week. We're having a hearing on the bill Friday, today, the week before. Hearings are supposed to give us a chance to step back and assess legislation well before they're marked up or make it to the House floor. But there are 0 business days between our hearing and this legislation and the scheduled markup vote. That's unfortunate because I think this bill has some very significant problems. I'm concerned that the legislation could open up the Emergency Rental Assistance Program to waste, fraud, and abuse. One of the most irresponsible provisions in this bill, which appears to be completely one-sided partisan Democrat bill, which we've seen too much of in this Congress, is it requires self-attestation from a renter to be considered as proof of eligibility for the program. That means an applicant could self-report their income and receive rental assistance from the United States taxpayers. No documentation, no verification. If someone simply tells the government they're income eligible for the program, we just take their word. This bill would say take their word for it and give them the hard-earned taxpayer dollars. I was pleased that my colleague, Congressman Andy Barr of Kentucky, mentioned earlier in his comments that we're talking about the use of hard-earned taxpayer dollars here, not money that grows on trees that the government just has. The government doesn't have any money they'll first take from the United States taxpayer. It's their money we're watching over here. So my question for Mr. Winn and Mr. Schwartz, my question is directed to you, Mr. Winn and Mr. Schwartz. When a potential resident begins the process of moving into one of your units, can they self-attest their income level, or do you use some means of verifying their income level?
So I can answer that as it relates to governmental programs that we help administer, like the low-income housing tax credit or Section 8. Yes, there has to be verified income for those federal programs. So by and large, we do have that information in our own portfolio. For market rate renters, for renters that are not under those programs, we are not in the business of verifying their income necessarily. So I just wanted to point that out.
Schwartz?
Yeah, we do income verification for our residents. I guess my only point with self attestation is the download of these forms, particularly on lower income residents, has been a big barrier to getting the emergency renters assistance. And we do our best to help them, but self attestation would streamline the process. And I do think there's a capability of the federal government to audit the self-attestations through the tax returns and information the government has and catch people who are committing fraud.
Okay. Well, thank you for that. A quick follow-up to both of you. If you were forced to accept self-attestation as proof of income, would that cause you to be concerned about the tenant's ability to pay rent?
So I just want to say, I think the issue that we're encountering now as a country is not landlords getting paid too much out of ERAP, it's landlords getting paid too little. So I do believe that, if the attestation can help get the money out, there is the flip side of that argument is that smaller landlords are unable to have the follow-up required to often verify incomes themselves, right? So to make sure that the tax returns are properly dated, to make sure that they've filed it correctly. So I do believe there is a need to simplify the process. And to your question of would it put us in a position to take somebody as a tenant that we otherwise wouldn't have, I think the issue is they're already there. They're already in our units and we can't find a way to get them ERAP.
Yeah.
And I would just follow up, I know you're out of time, is we only verify once. We don't know after the tenant moves in what their income is. They could be with us for 10 years. We wouldn't know.
Okay. I don't know if I'm out of time, but I have a closing statement if I'm not out of time. Thank you for your comments. I want to say it would be
Thank
irresponsible.
you. The gentleman's time long expired. The gentleman from Massachusetts, Mr. Auchincloss, is now recognized for 5 minutes.
Madam Chair, thank you for this opportunity to work on this bill. I've heard a number of my colleagues on the other side of the aisle talk about the unconstitutionality of President Biden's actions. And while I appreciate that everyone in Congress needs to be laser focused on protecting the Constitution and holding the administration to account, I gotta say that these words would resonate more with me if we had seen this same kind of attempt on the Constitution in the last 4 years after the most egregious depredations of the Constitution in the history of the United States under President Trump. So I would encourage everybody of both parties to continue to hold presidents of both parties to account for protecting and defending the Constitution. I'm also hearing a tremendous amount of frustration again from both sides about the bureaucracy and the paperwork around it was grounded in good intentions and was really directed towards an extreme need. And it's made me be thinking a lot about the child tax credit. And the connection here is that I've seen over and over again empirically with federal policy that when we directly transfer money to working families, whether it's through the child tax credit or the earned income tax credit, they spend it on what they need and they spend it on a better future for their kids. And so the expansion of the child credit and making permanent the tremendous gain in childhood poverty reduction that were achieved in the American Rescue Plan and reconciliation can be viewed not just as expand improving social welfare, but also as in the long run obviating the need for some of these programs that I know my Republican colleagues get frustrated with for sometimes being inefficient or bureaucratic or increasing red tape. Just give money directly to people and those needs without being market distortion, without creating a new level of federal bureaucracy. So I'd encourage you to think about the child tax credit in that lens. I'll pivot now towards the program in question. And again, Madam Chair, thank you for the work that you've done to help correct some of the flaws we've had in the distribution funds. Earlier this week, a local news station, WBUR, renters in the southern part of the district I represent in Bristol County, were twice as likely to have been evicted during the pandemic. And they've actually seen more authorizations for evictions in 2 cities, Fall River and New Bedford, than in Boston, which is a city 6 times their size. There's a lot of reasons for this, but one of them, the article pointed out, is that some renters do not even earn the rental assistance at all until they are actually in eviction court itself. And sometimes they're even learning the rental assistance even in eviction court. I mean, they're literally getting evicted through the court process and never have been told about it. So I'd like to focus on housing courts and their role as sort of the last tripwire in this whole process for making people aware of their rights. Ms. Salazar, so you could start by saying if you've seen any programs that are effective that the courts are doing their job.
Thank you, sir, for that question about the role of courts in eviction diversion. I mean, certainly our hope is to be able to respond quickly to get rental assistance into the hands of tenants before we reach that point. But one of the things that we're seeing work really well is that our local program administrators on the ground are collaborating with the court systems to intervene and directly get rental assistance into the hands of folks that have received a filing. And so it's those kinds of relationships and cooperation that are absolutely critical. And I would say that one of the things that's helpful in the chairwoman's bill is, you know, more focus on administrative dollars, technical assistance, and the support for local community-based organizations so that we can set up those kinds of effective programs to engage the courts in the solution.
And in my final minute, Ms. Salazar, again, perhaps you can, but each witness in turn could say for the sacred whether you support self-attestation as programmed in this bill.
Thank you for the question. Self-attestation certainly speeds the provision of rental assistance. What we've seen in our own program in Oregon is that some of our local administrators have been quick to adopt self-attestation as part of the process, and some have been slower to adopt it for various reasons. And when we see it utilized—
Sorry, I apologize for interrupting, but I've only got about 20 seconds. I want the other witnesses quickly to say if they support self-attestation or not. Mr. Morris, perhaps you next.
I do support self-attestation.
Thank you. And Mr. Winn?
Yeah, it's not a perfect solution, but I do think it's required at this time to get the money effectively.
Thank you. And Mr. Schwartz?
Yes, I support self-attestation.
And we strongly support it as well.
Thank you all. Madam Chair, I yield back.
Thank you. The gentleman's time has expired. Do we have any more members on the platform that have not yet participated? If not, I would like to thank all of our witnesses for having been here today and providing us with very valuable testimony. So without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their responses. I ask our witnesses to please respond as promptly as you are able. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. Thank you all, and with that, this hearing is adjourned. Thank you.